So we here acknowledge the chairperson, and we are honored today by the guidance of Revati Raghunathan, chairperson SIRC of ICI, Dr. Abhishek Murali, RCM of SIRC of ICI. So our chief guest, Justice Chitra Venkatraman and Advocate Sharath Chandra and Mr. K. Ravi. Yeah, thank you for bringing such high value practical training to our region. So to begin with the proceedings on an auspicious note, may I request everyone to raise for the invocation followed by the ICI motto song.
येष सुप्तेषु जाग्रति येष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तदेव शुक्रदब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Thank you. So we begin with lighting of the lamp. So may I respectfully invite the dignitaries, Justice Chitra Venkatraman, retired, and Revati Raghunathan, CA Sunita Sivaraman, and CA Abhishek Murali, and CA K. Ravi, past chairperson, to accompany, sorry, to join the lighting of the lamp. We now request our chairperson, CA Revati Raghunathan and Abhishek Murali, RCM, to kindly accompany Honorable Justice Chitra Venkatraman and join us on the dais. Okay. To formally inaugurate. We formally inaugurate our proceedings. I am delighted to invite our esteemed chairperson, Revati S. Raghunathan, to deliver the welcome address.
A very warm Good morning to everyone. I always, feel that if you invite someone to whom you have a enormous, enormous respect, because of the various conversations with you have with them, the various professional interactions you have with them, and the way your respect for them builds, and the way your self-confidence also builds along the way. Chitra Venkatraman ma'am is one such person who I always consider to be a role model to all women, and particularly, a person who has motivated me a lot. And she still continues to motivate, and every session where we talk with her, there is always something to take away from her. And there are some moments when you feel a little low, when you feel, okay, I can't go on, I'm feeling very overwhelmed. And then somehow, the energies conspire to for some meeting or conversation with ma'am, and then I'll go all back with renewed pep and energy. So thank you very much, ma'am, for accepting our invite. When we actually planned and curated this program, I could not think of anyone other than ma'am to come here for the opening session. And she said, what will I talk? What do I know? I said, ma'am, what is this? How can you even say that? And I'm sure she's going to set the tone for today and tomorrow's program. They say anything well begun is the best way to do it, and we could not think of anyone other than ma'am. So tax litigations, we all know, is going to be the order of the day and one of the most brightest verticals in any chartered accountant's practice. And as we started curating, designing and talking to various people, I realized that the number of serious practitioners as chartered accountants in this area is not as many as it should be. Okay, maybe because we are too busy doing all our other work, all our returns filing, and the regular work which a chartered accountant does. But this is one area, and when I spoke with advocates also, I happened to speak with some past current sitting ITAT members as well as past ITAT members, and they said the number of chartered accountants who are actually practicing in this area are few and far. And Gestat is something which is actually opening up. There's so much. I'm sure that once the Gestat tribunals are in place, the rules, regulations have been notified. I think even the judiciary are slowly being selected. And so once it opens up, there's going to be a tsunami of opportunities for all of us. And this is something which we should all actually equip ourselves in. And I believe that, while we are technically extremely savvy, all chartered accountants, extremely savvy. GST, everyone will come out with all the provisions of GST. It is how we are actually going to go and represent ourselves. So if you see today and tomorrow, we have predominantly chartered accountants and advocates. Advocates are the people who are actually showcasing everywhere in the tribunals, but I thought that if we call the advocates, invite the advocates, they will be able to guide us where our shortcomings are, and we can also take some pointers from them. And of course, some very extremely successful chartered accountants are also practicing, and they are also going to be talking here today. And we decided, they said we need Courtcraft, we need courtroom drama, we have to make it very engaging for the participants. We need to have some highly contentious cases. It was actually, their ideas were flowing, and for us to actually say stop, we are having it only for 2 days, and the moot is only for half a day. Okay, on both the days it's half a day, because we thought there should be some content takeaway also for us. So the moot is for half a day, and the number of ideas which came was really mind-boggling. Apapa, I'll nod my head, yes. I didn't want to show my ignorance to all the people to whom I was talking with. And we have Mr. N.V. Vasudevan, who was the past Vice President of the Income Tax Appellate Tribunal, and who has now really seriously taken it like, I must do my best. It's actually like he's going to conduct an ITAT proceedings. He's given us so much of literature for this. And he in fact said, I want a courtroom set up. I want so many things to happen. I want these books to be here. I'm going to make a PPT because I find that chartered accountants are slightly hesitant in so many different ways. And then we have Mr. Gopal Mundra and Mr. Ranjit Matani from Bombay, advocates who are coming as presiding officers for the GESTAT, who have they had so many Zoom calls and team meetings with the councils, and everyone insisted that they need a court master also. So we have a young chartered accountant who's going to be a court master and who's going to announce the cases and do everything. So we have tried to replicate everything which happens in a tribunal over here, and we have been guided very effectively by all the senior advocates and the past chairman of ITAT and all the members who are also practicing. And we are having 2 sessions, one on burden of proof and evidences by Advocate Sharat Chandran, who is there right on top in these matters. And the number of books he has written is I can't even list out the number of books he has written. And they were also generous. You just have to ask them. And today morning he called and said, I'm sending the PPT, ma'am. They're so humble. I mean, this is not something which I expected when I interacted with all these people. So I'm actually flabbergasted by the way that they all interacted with us. And we have Advocate Karthik Sundaram, one of the leading advocates here in Chennai, who decided on the cases and how everything has got to be taken forward in the GESTAT. And we have our own chartered accountant advocate, Jatin Christopher, who we have all seen him in various forums where he comes and talks to us. But he's also one of the most humble chartered accountants who's there on the top, who says, don't worry, ma'am, I will take care of everything. You do all the other work. So these are the people, these are the stature of the people who have actually accepted our invite. And we decided to have it in a place like SAVERA, where, we know that people who are actually interested in this practice or who are actually in this practice, serious practitioners will be joining us. And it is very heartening to us at SIRC that we have more than 150 registrations, and I hope that both the days all the registrants will sit here, enjoy the benefit of what has been put together, enjoy the courtroom drama, the Courtcraft which is going to be discussed, and also the content which is going to be delivered by all the speakers. And also applaud all our own chartered accountants and all the advocates who have actually spared their time. And you all know that any invitation by SIRC is deemed to be a very honorable invitation, and they showcase themselves, but there's nothing else for the speakers to take away other than the plant and other small mementos that they give us. And last but not least, this is not a vote of thanks, I'm just telling, I want to thank Advocate K. Ravi sir, who actually helped me to put together in this entire program. Like, in Bharatanatyam, there is one terminology called as korvai. So you take different parts and that is how your entire dance item or your program is a success. So the core way, the curation of all the topics, the speakers, everything was actually, I would say he's also one of my mentors who was put together by him, past chairman K. Ravi sir. And sir, I'm deeply indebted to you for whatever you have taken up to help us in putting this program. And of course, to all the delegates who have come here to takeaway. I think I'm also going to be a delegate and sitting there, my takeaway is also going to be huge. I have a little idea, a little bit of the suspense is there for you. For me, it's not there. But still, I'm also looking forward to hearing all these people and participating in this. Thank you very much, everyone. Ma'am, thanks once again. And both from my behalf and also Abhishek's behalf, our regional council member who has come here to ably support me today. Thank you very much.
Thank you, ma'am, for the thoughtful words and delivering the welcome address and setting the tone for today's program. So now, to honor the chief guest presence with us today, I invite CA Revati Raghunathan to adorn the shawl to Justice Chitra Venkatraman, Judge, Retired High Court of Madras. As a token of our respect and appreciation, I invite CA Dr. Abhishek Murali, RCM of SIRC, to give memento to Justice Chitra Venkatraman, Judge, Retired High Court of Madras. I now have the privilege of inviting our chief guest, Honorable Justice Chitra Venkatraman, Judge, Retired High Court of Madras, to address the gathering. Before I just read out the profile of Justice Chitra Venkatraman. She born on April 22, 1952 in a family of professionals. She had her school education up to 5th standard in Sri RKM Elementary School, T Nagar North. Thereafter, she pursued her studies from all these schools in RKM Sharada Vidyalaya Girls High School at Srinagar, Chennai. She completed her graduation studies in BA Economics in Etaraj College for Women, Chennai. Okay. So, she joined the office of Mr. Justice V. Ratnam before his elevation to the bench, who later became the Chief Justice of Himachal Pradesh High Court as a junior. So, particularly to the field of taxation was acquired by her by watching in all the great discussions that went on the floors of her house between her father, late Justice V. Balasubramanian, Judge High Court Madras, late Mr. Jagadishan, Chartered Accountant, and other family members, irrespective of their age, including her paternal grandfather. Starting from her maternal grandfather, her maternal grandfather, and her father in the legal profession, the chain of successive son-in-law in the legal profession as a norm was perfected by her father by giving her in a marriage to Sri R. Venkatraman, now a senior advocate, in whose family is also a family of lawyers. So next, she retired in 2014 and successfully commenced her next stage in her career as an arbitrator and a tax consultant, and more importantly as an active grandmother to twin grandsons. I now invite Justice Chitra Venkatraman, Judge, Retired, to the dais.
Good morning to everyone. Indeed, my pleasure today to sit along with a highly empowered woman from whom I draw a lot of energy. If I am energized today, I owe it to her. Very colorful person. And no wonder, when you have an empowered woman at the helm of affairs of the South Indian Regional Institute of Chartered Accountants, you are bound to have a colorful journey throughout, very energetic journey, and it is going to be an empowered journey. It's not just a small journey for you. I have interacted with her for nearly 10 years, I suppose, but more with Mr. Raghunathan. Whenever the team has some kind of a low energy, suddenly a fresh air comes into the room in the form of Revati. We all sit up, have fun, laugh, then we have some small chit-chats, that ends, again we resume our work. That is how the whole thing started. So, contrary to what she says, or I would say it's a mutual one, a respect for each other, not as just professionals, beyond that. That's what I would say. When she asked me to accept this program to preside over, I did have my doubts about the capacity to which I can rise up, or the expectations to which I would rise up, because I have stopped practicing a long time back. After 2014, I have not appeared before the court. After 2005, I was on a pedestal. You call it an ivory tower, or iron tower, whichever you may call it. But it made no difference to me because the passion on the field of law is an evergreen one. And even today, even though I have retired, it stays on. Of course, I don't go to the High Court to know what is happening there, gossip, or on the corridors. I miss very much. It was a second home to me. It's a passion to go to the High Court every day. I don't know why. Even if I don't visit my mother's house, if I don't go to the court even for a single day, it's so depressive. See, that is how the whole thing is so infectious, I should say. I enjoyed my stay there, both as an advocate as well as a judge. And the grandeur of the building, even today, brings in good memories about the place, a lot of confidence infused in me. I think this is the first time that you are having this kind of a moot court experience, which is the most welcome aspect of your career, I should say, part of a training. When we were all doing our law course, we didn't have a formalized moot court exercise, which is a recent year development, thanks to the endowments which had been generously made by senior advocates, in whose name these endowments were all created. And young boys and girls participate on various subjects, right from labor law to taxation to constitutional issues. And if you just look at it, you feel ashamed of what you wear. That's how things are. But anyway, appearance before a court of law is a matter of pride. Wearing a coat, Ravi is laughing at me. I don't know why. I thought you also held that view. No? And all of us had our beginning, I should say, initially to some extent before the tribunal's appearance. Many of you may not know about chartered accountants who were members of the income tax appellate tribunals. D. Rangaswamy, the firm you know, he was an outstanding member, accountant member there. Sadagopachari was also the president, was an outstanding member there. C.A.G. Krishnamurthy was there. He was a chartered accountant. All of them are all chartered accountants. Chartered accountant cum advocate was Justice Ishwar. So, what I found in my initial years of practice appearing before the tribunal was there is practically no difference between an advocate appearance or a chartered accountant appearance, a hearing before a judicial officer, and a hearing before an accountant member. Sometimes they sit single also. So informal. They used to say the Battle of Waterloo was won on the grounds of Eton. That was a training that they said. I would say to many of us, Income Tax Tribunal laid the ground for learning so much and unlearning so much also, I should say. The grandeur of appearance, be it a High Court or a tribunal, stays forever. So that's how I perceive about an appearance. Now on to the topic. Before I go into the depth, I would just like to say briefly about what a tax system is, administration is. Because without knowing what is tax, what is the nature of a litigation as you call it, we don't call it a litigation. It's a dispute, we call it. Up to the level of the tribunal, it is only a dispute. We may call it an appeal or whatever it is, but it's not a litigation in stricto sensu. I'll just briefly touch on what is the origin of this tax. Just 5 minutes, I won't bore you, I assure you. See, in olden days, we didn't have a formal income tax liability at all. There is no taxation system stricto sensu as we have today. 1/6 of the produce was collected. Why? Just to meet some warfare expenditure, not for any developmental activities. If the king has no money in his thing, he simply asked, why don't you give 1/6 of your produce? You are having so much of. This is how things were. Of course, there were arbitrary demands and everything, but there was no form of appeal, a structured form of appeal before any authority. If you are an influential person, you go before the king, prostrate before him, get some relief. That is how things were. After this, of course, during the Mauryan period, we had some organized system of levy of tax. We don't deny that. Probably that is the beginning. You must have heard about the Sangam period literature and all these things, how the king should take money from them by way of tax and all. Let us not go into all those things. But after the Sepoy mutiny, when the British government had no wherewithal to survive on this land, they introduced for the first time income tax levy in 1860. That is to tax an individual or corporate on dividend income, salary, rent, so on and so forth. What was the appeal or whatever? If there is a wrong assessment made, a wrong demand made, you can approach the in-house resolution center, and very rarely people went up to the High Court and then to the Privy Council and all those things. So formally, there was no such system as a structured appeal provisions. 1865, it lapsed. Then 1922, I am skipping some of these in-between acts, we are not concerned. First time in 1922 Act, we had a structured appeal provisions, but they were all in-house only. They are not like a civil court proceeding. But then, as against orders of the appellate authority, as against the final fact-finding authority, which is income tax tribunal, you can appeal to the civil court, from there to the Privy Council. That is how things were. So, even in these forums, the appearance of a chartered accountant was not visibly there. We have only Kanakalar, or whatever you call him, an assistant, accounts assistant. He will sit behind the assessee, informally he will say, this is the account, it is that, that is all. If the client is not ready to listen to him, or he wants to sail along with the officer, his job is over. He will be sent out. That is all. Because the assessee always wanted to be in the good books of nursing officer. He is at his mercy. That is how things were. So they towed the line of what the officer said, and that is how things were. Despite all these things, we had very good judgments from Privy Council and the High Court during those times. So leave aside those legal forums for a second. So 1922, the chartered accountants did not have the authority to appear as an authorized representative even before the tribunal. Now you have your Institute of Chartered Accountants formation sometime in 47 or 45? 40? 49. So even though there was chartered accountants during 1922 or certified accountants, only after the introduction or the statute was introduced and there is a formal recognition of the profession, under the 1961 Act, you had the right to appear before any authority as an authorized representative. So the recognition to the chartered accountants profession came only in the 1961 Act. It continues even today. Strictly speaking, I would say there is no difference between a chartered accountant's profession and an advocate's profession. Why I say that? Many a case, the chartered accountant is an advocate for an advocate. He's not just an auditor. In many a case, an advocate is a chartered accountant for the chartered accountant. The role is like that. Why I say this? Because financial transactions designs, structuring are all a contribution of not just by one professional, because they are all overlapping, the interests are all overlapping, that is how things were. So the change that had been brought in by this representation had taken these professional rights, and there comes the recognition of members of chartered accountancy profession to be a technical member in the tribunals. That is how things are. Now, you all know a tax is an exaction. But not anybody and everybody could levy a tax. If the state has to levy a tax, it has to have an authority. Article 265 of the Constitution gives that authority to the state to levy tax. So, according to the provision, no tax shall be levied or collected save with authority of law. So, the fundamental principle under which tax is levied is Article 265. In pursuance of the constitutional provisions alone, we have a tax code. So, what is an assessment then? It is merely a computation of what is your income, what is your liability under the code, which is calculated in accordance with the scheme of the Act, nothing beyond. My assessment has to fit in with the provisions of the Act. If it goes against that, or any claim is denied, or exemption is denied, or some addition is made, then there is a dispute between me and the state, not the income tax officer. Please note that. You are one side of the coin, they are the other side of the coin. So there is no conflict of interest in the sense of a litigation to be called so. Therefore, all tax differences, conflicts are disputes simpliciter and not tax litigation. Please keep it in your mind. What is an assessment? Assessment is an adjustment of a tax liability to fall in line with the scheme of the Act. That is what an assessment is called. Therefore, when an assessing officer quantifies your income or a liability, he is only discharging the functions which are given to him under the Act to toe on the lines of the scheme of the Act. He cannot go against that. So, sitting as an arbitral tribunal, you may have a litigation per se to be decided. What is a litigation? Difference between dispute and a litigation? Dispute is merely a controversy or a conflict or a dispute, simpliciter in the sense of an adjustment to be made of what is returned as an income in terms of the provisions of the Act. In that, we don't have a legal system per se to interfere into a decision on rights and liabilities, unlike in a civil case, where you have a legal process by which you settle a dispute. So there is a major difference between a tax litigation. There is no opponent call, a respondent, simpliciter as you have in a civil case. The state is there on the opposite side only to see that the right income, a right person is assessed for a right liability. That is the theme of the taxation law. Right person, a right liability, and right time at which it has to be assessed, nothing beyond that. Therefore, when a person is offended by an assessment on addition or denial of something or whatever it is, which goes against the facts that you have pleaded or which is against the provisions of the Act, a dispute arises between you and the other side. We don't call it as a list at all. There are judgments onto that. You just go into the Google or whatever, it's not ChatGPT, but go into the Google, you will get all these things. So you get the decisions. So when an assessment is having an harmful effect on an assessee, the next thing he has to do is, as per the structured provisions, you go on appeal to the better wisdom of a higher authority under the statute. Appealing is for a correct result on what I have returned. That is an appeal. It's a very loosely used word. So what is an appeal then? It is a corrective measure provided under the Act, and it is not something like a litigation which you invoke under the Civil Procedure Code. The difference has to be there because it will have to shape your appearance, the modality of your approaching the facts and other things, the presentation. That's why I'm emphasizing on that. So the courts have held, considering the fact what is a liability under the Act, why an appeal provision is given as a corrective machinery, they held the authority and jurisdiction of an appellate authority is coterminous with an assessing officer, which means it's a continuation of an assessment proceedings. You don't have a full stop there. After the assessment, you go to the appellate authority. It is a continuation. Why they say that? If you had failed to file a form, make a claim or a wrong claim, or somebody is omitted to have done something, then you have all the rights before the appellate authority to give them. Either as an additional evidence, you can make alternate pleas also before the appellate authority. So when the appellate authority's powers are coterminous with that of an assessing officer, he can annul an assessment, modify an assessment, enhance an assessment. Please note that, enhance an assessment, cancel the assessment, remand the assessment. He can receive fresh evidence, fresh declarations, and whatever is to be there. And he can even summon an officer to explain what is what. But invariably in an appellate proceedings, there is nobody called a departmental representative to sit and assist the commissioner. He doesn't. And the backside, he may do so many things. We are not concerned. But just in front of my eye, I am there, my representative is there, the CIT is there. That ends the matter. All right. So, in 187 ITR 688, Jute Corporation of India said, yes, is coterminous with the assessing officer. But only one beautiful aspect of an appellate authority's power is, in a court, if somebody is not appearing, the litigant is not there, he can dismiss it for default. It's a different thing. I file a petition to restore. I can file any number of petitions to restore, any number of default I can do. Yes, Ravi, right? Okay. But surprisingly, and it's a saving grace, I should say, of an appellate authorities forum, there is no such thing called dismissal for default. He cannot do that. So that explains the significance of a role of an appellate authority as person continuing the assessment process for an adjustment of a tax liability. So that's such a beautiful provision, I should say, which most of us have not had an opportunity before any court of law. So with the structured mechanism, I said, you can restore the order, do whatever you have to do. After the orders of the appellate authority, we go before the tribunal as a fact-finding authority. In one judgment, I don't remember immediately, they said, the income tax tribunal is a Supreme Court on facts. That's what they said. See the significance of that. Why Supreme Court on facts? As against an order of a tribunal on any finding of fact, there is no appeal before the court. The court will not look into the facts at all because it is settled by the tribunal. High Court is concerned only by the questions of law raised. Now, prior to 1998, we had what you call an advisory jurisdiction for the High Court. It's a very special provision, I should say, because income tax is always, the act is, the provisions, everything is, scheme is held on a higher platform than any other law in the country. In fact, I had heard somebody saying, next to the Advocate General, who will sit? Counsel for Revenue, not anybody else. That was the respect that the Act had, the weight that the Act carried throughout in the administration of justice in the country. So what is an advisory jurisdiction? After the disposal of an appeal, I approached the tribunal. Look, I have a case referable to the High Court. Get an opinion from the High Court as to whether your order is correct or not, whether I have a case at all or not. Sometimes you see the generosity of the tribunal because the advocate profession also has to thrive. I don't need to put a full stop just before the tribunal. I need to grow. So 256(1) is liberally done. Sometimes, if I got from the wrong side of the bed, yes, I dismiss your 256(1). What do? I go under 256(2) before the High Court to direct the tribunal to call for a case to be stated to the High Court for its opinion. Even there, before the High Court, when it asks for a statement of facts, the enclosures, everything will be there. Then the argument goes on mainly on the question of law propounded by the High Court or the tribunal which is approved by the High Court. So pure and simple, High Court jurisdiction was only on question of law. After 1998, there is an amendment by which instead of advisory jurisdiction, 260A was introduced, which is a second appeal to the High Court, which is a form of a substantial questions of law as like section 100 of the CPC. Even here, High Court will not go into the facts. It will only look on the question of law, substantial question of law framed by the High Court on a case presented before. It's before a division bench only. So, thereafterwards, you have a further appeal before the Supreme Court. We need not go into all these things. This is the scheme of an appeal provisions under the Act. Now, I said the chartered accountants have now an opportunity to go before the Appellate Tribunal as a representative, to participate in all the deliberations there. Your journey, therefore, starts from designing a financial structure, maintenance of accounts, overseeing of accounts, filing of the return. It doesn't stop there. Appearance before the officer. If it is not successful, if he doesn't like you, go before the appellate authority. If he doesn't like you, come to this tribunal. It is a matter of pride, I should say, that you have the opportunity to appear before the highest fact-finding body under an act. You had very eminent persons occupying the chairs of the tribunal. Mr. George Sherian was there, O.V. Subramaniam was there, S.P. Subramaniam, so many names. I lost track of it because after some time I didn't go before the tribunal at all, got stuck up in the High Court. So the advantage you all have as a representative is, which starts from the very nascent stage of advising the assessee, your technical expertise, law on the subject, particularly taxation, the manner of maintenance of accounts, what is to be disclosed, what is not to be disclosed, how to arrange the affairs of the company or the individual for reporting, how to claim a deduction, how to claim an exemption, how not to claim an exemption or a deduction, whether to get a concessional capital expenditure, revenue expenditure, current repairs and all those things. Sometimes your contribution has also brought in several amendments, several good law laid down by the High Court. You are the chief architect in bringing many an amendment, I would say. What about the depreciation provisions, dividends, MAT? And when there is a conflict between the company law and other things, you are the one who resolve with all the accounts and everything. Therefore, your expertise is no way below what a advocate will have. In fact, it is superior at times to an advocate's. Mr. Ravi? Right? Because, you know one thing, we always hold, there is a personal experience I'm telling you, when handling certain appeals before the High Court. Out of a great interest in showing your proficiency in law on the tenets of income tax, many times you strive to put forth a legal argument rather than bringing a factual matter for a settlement before the tribunal. Please remember, facts must fit in with law. It is not the other way about. You don't bend law to fit the facts that you have. In overzealousness, you always project the legal provisions, the judgments, circulars and whatnot, forgetting for a moment whether it is applicable to the fact situation on hand. The net result is, when you are on your legs before the High Court, you blink. Yes, many cases are lost only because of the absence of a nice, full, full-fledged fact-finding in any particular case. I was a victim of that. I was a beneficiary of that also. Beneficiary in the sense appearing for the state and appearing for the assessee. Yes, I have lost. So my request to you is, whenever you appear before any authority, stop for a moment referring to case law and all those things which you think will be of great pillars of support to you. Start with narrating the facts. Leave the authority to apply the law. It's always better. Why I say is, it gives you a leverage to go on appeal. Otherwise, if you mess up there, the messing continues and continues, because the ones who are sitting on the dais are not always endowed with better wisdom than what you have. But we go on an assumption that it's not so. What you deliver in the court, what you deliver before the tribunal, what you do before the officer alone gives a good result, a good decision, which stands for years and ages together. That is one thing we'll have to see. Now, how do we prepare then for a role as a legal representative, an authorized representative? Advocacy is a multi-talented art. Please note that it is not an exclusive domain of a legal profession. You also belong to the legal profession. You may not have BL degree, but still I would say you belong to a legal profession. So this requires, advocacy requires, starting from knowledge of the provisions of the Act, knowledge of various enactments that are there with which you have to deal day in and day out while interacting with the client, a very strategic thinking which you have to develop as to how to place your case, how to place the figures, how to draw facts out of the figures, how to draw legal provisions out of this, and where legal provisions are ambiguous, how to come out of that and be a successful litigant. That is how it has to be. So the tax dispute or before a forum requires not just reporting of accounting figures, but something beyond that. Therefore, the first step on your practice starts with thorough knowledge of provisions of not only the accounting principles, but knowledge of law. Beyond the knowledge of law, which I say it's not just tax law, all allied laws, there is a passion to fight for a cause, a passion to establish with conviction as to what you plead for your client. That has to be there. So Mrs. Revati said something about, what is it, the link or something. You said something, no? This chain or something which has to be there, in the loop which have to become. We have to be there. From what I have learned out of my practice for fairly 35 years, I think I have completed 50 years of enrollment, not practice. I can say whenever a dispute has to be made before an appellate authority, the entire exercise has to start from fitting in with my name, beginning with C. Every step that I'm going to say goes with the initial alphabet of my name. First, canvass the cause before the tax authority. What is the facts that you are doing? Canvass the facts, assimilate the facts that you are going to plead, which you had pleaded before the tax authority. Then, from the context, you find out what is the dispute that you have to plead. To identify the dispute, you need to have a critical thinking. See the C, critical thinking has to be there. The critical thinking as to the cause and the merits of filing an appeal. Committed to the cause of your party whom you are representing, committed to the cause which you are pleading, you need to go in to a track of a creative, critical approach to the problem in the matter of preparation of grounds of appeal. The drafting is a very big art. Unless there is a clarity in what you say, no court will accept. I'll tell you one reason why. That was before a tax bench. But the tax bench had other matters also. It was a writ appeal or something was there. It was Justice Ram Prasad Rao, I think. Long time back when I started my career. When the counsel stood up, the judges were so annoyed. He said, without hearing you, we are dismissing your case. This man just couldn't say anything. No, I have a good case. You may have a good case, but you have a very bad typewriting, bad drafting. I don't know what is what. We are dismissing it. See the sternness with which this is dealt with. And recently in the Supreme Court also, some judgments were commented about, lacking clarity. Therefore, the hallmark of good preparation in the communication is clarity of thought, what you want to convey as a case pleaded by you. Now, clarity comes along with good communication ability. Communication in the form of your written submissions and whatever it is. The disciplined way of preparing the grounds of appeal. Disciplined way of preparing the paper book which you have to show in support of whatever you will not go into the decisions just on this. Now, after these are all the core themes that you have at the time of at the threshold of filing an appeal. Once you file an appeal, what begins with is the presentation of facts, the clarity of your presentation, the sequential statement of the facts to bring out what exactly is the dispute that you are pleading. You don't start with legal provisions, status of law, statement of law, or whatever it is. Now, what is communication? What I want to convey, the receiver must be in a position to understand. And what the receiver asks you, you must be in a position to understand. Therefore, you'll have to keep your antennas all the time open to receive whatever is happening there. At the same time, effectively put forth what you are pleading for. Now, at times, there may be kind of a disinterest shown from the bench. Some murmuring from the back. Hey, in the point sola the appdi pace, ipdi pace. All kinds of pro bono ideas will be flowing from the back. The poor chap, company representative and assessee will be just flabbergasted by the entire thing. Revati said you have to have a courtroom set up for this thing, you know. But I don't think we have in tribunal that kind of a thing. Originally they had, they were so royal. I tell you, the tribunal members, they behaved so royally. I don't know about the present day thing, fortunately. And sometimes they used to think, because I am the final fact-finding authority, my status is much more than the High Court. Therefore, they will shoo, talipong, pong, pong, something, all this kind of a thing will be there. And someone who had been in the High Court, I used to look at it with all contempt. I'm very frank on that. Why at all these people are behaving like this? And we have a judge in the High Court who snubbed all these practices. Just Chandru, he said, I will not have a Diwali in front of me. I'll carry my papers on hand. I'll walk like this, hit against everybody and go. You'll walk very fast. The only fear is if he's sitting on you or stamping on your little toe, now I may have to go to the doctor. There will not be somebody to attend on me. That's the only thing. No, so this, why I'm saying is, we don't have courtroom dramas. We don't have. Very sublime way of dealing with things. Totally disinterested. For a first timer to a tribunal or to a court, what is happening? சிவாஜி கணேசன்லாம் அவ்வளோ அப்படியே பிரமாதமாக நடந்து கத்திட்டு பேசுவார். வாட் இஸ் ஹேப்பனிங்? That's how people used to think. But even in that silence, there is a beauty and grandeur and grace, which you have to feel it on every part of your body, every nerve of your body. Sometimes, beyond the advocate, nobody will listen, nobody will hear what is happening. Only the advocate will know what the judge is asking. The visitor at the back will say, what is happening? Nobody is able to hear anything. That's how things were happening. But tribunal is in a smaller room, therefore everybody could hear what is happening. The ambience is good. The treatment is good. A very friendly atmosphere. More than anything else, the departmental representatives were never behaving like an opposite side counsel. Except for one or two. Mr. Ravi knows about that, I don't want to name. I don't want to breach confidentiality. Most of 99.99% are drawn from ITO or Appellate, Assistant Commissioner or whomsoever. You are all very friendly. If something is left out in your arguments, they will immediately say, or he will rise up and say, he omitted to argue this part, this is covered by this is covered by. That is the friendly atmosphere which we had. But that doesn't mean my communication has to suffer on that score, because I am conscious of the image which I have to maintain before the tribunal and for my client's sake. Otherwise, next time he'll run away from me, wait for the officer to retire and go to him, which I don't like. Therefore, when I make a present clarity, my arguments have to be concise. I stand up with commitment, confidence, conviction that I have a case which has to be looked at in all fair manner. Now, the composure is a very important aspect of it in proceedings when you appear. Apart from the composure, the dress regulations also matter a lot. That brings dignity to the profession. So, collaborating all these things for a good presentation. You must remember one thing, that when you are pleading for a case of your client, it is not in every case you can expect that you will be winning that. Sometimes you have a very weak case, you know that. Still, if you fight like anything, the image that you present also matters. It affects your future also. That doesn't mean you should not fight, but you should know the limit up to which you should travel to press your case. That's what I want to say. That's one thing. Second it's a very important thing. The success of appearance or winning a case does not just be restricted, as I said, to winning an order in your favor. What you fight for is a fair, just adjustment of your tax liability. That is all. Therefore, when you plead a case, you make sure that even the worst of the mind will not mistake your arguments. This is a compulsive argument that you are making to accept your case. Ultimately, when you receive a judgment, this is also very important. It's a code of conduct which you have to have in mind. A judgment is passed, an order is passed. When an order is passed by the High Court, we don't say, but today the practice is slightly different. The High Court has passed an order. That's what we say. We don't name the author of the judgment. So and so has passed the judgment. No, it is never done. When the order comes from the High Court by a division bench consisting of A and B, it is not a judgment by A and B, but it's a judgment of the Madras High Court. So when the tribunal bench passes an order, it is not an order passed by A and B, but it is an order of the tribunal. The point I want to drive is, you may be critical of the merits of the order passed, but don't ever be critical of the author of the order, the person who wrote the order. That's very important. What is it he has against you? He doesn't have, right? So, whenever a judgment comes, an order comes, be careful as to how you react to that. Your reaction principally on the merits of the order passed by the tribunal and not an order by X or Y. That is a dignity that you have to maintain because you are part of the system of tax administration. The avenues of advancement that you see today in the chartered accountant's profession is remarkable. It's a good work which has yielded the result. You must have read about the latest Supreme Court decision which said, treat a chartered accountant on par with an advocate as far as the work experience is concerned, the professional experience is concerned. Why do you have 25 years requirement for an appointment as judicial member, accountant member in a tribunal? It's an arbitrary. Therefore, make it as 10 years as an advocate. So, the reason why I'm saying is, both are part of a system. You are all pairs of eyes, advocate profession and this, one pair, which has to go hand in hand in the march of law. One of you or both of you, many of you may be chosen as members of the Income Tax Appellate Tribunal. There are so many other tribunals which have, I should say, the status of a court, I should say. Take the national tribunals that we have. Do you call it just a quasi-tribunal? I don't think so. They're headed by a Supreme Court judge, Appellate Tribunal, NCLAT is there. The mark that you have made before NCLT in all IBC, she's an expert. See, there's something very, I keep watching some of this, some article, something comes. I used to think, I wish I do pass that examination to appear. So interesting. Counting others' money is always an interesting thing, you know. More than your own thing. So, with the avenues available, I'm confident, clothed with patience, expertise, knowledge, critical thinking, awareness about what is happening around you, the exposure to the various legal system available, laws available in the state. I'm confident that this profession will take you to great heights, not just as somebody appearing before a tribunal, but as technical members of great forums, judicial forums. So to conclude, I should say I had a very gratifying stay as an advocate. I loved it. It is not just defending the state or the assessee. Standing before the court itself is a matter of pride. That's how I felt. The pride that we have, I know, is also going to be there for every one of you. All that I realized at the end of my career is, or every case that I fought for, the conviction that I had in defending, the preparedness thoroughly, that gave me full of satisfaction. I may lose a case, still the pride of arguing the case, full conviction, full preparation, always had an impact on me. More than anything else, if I have somebody like Ravi opposing me and coming to me and saying, Chitra, you did a good job, even though you lost the case, you argued very well. What to do? The decision is by that man. He doesn't understand that law. That is what he will say. So that is a matter of pride which I carried in my career. So don't worry about losing the cases. Every case you lose is a stepping stone for a success in the next case. Keep a minutes book like, starting from the day you advise your client on a particular thing, you structure the financial thing, how you have advised, what you have advised, what you projected before the officer, what you pleaded. These all have to have the legal-based decisions, procedures, and whatnot. Therefore, as a professional who is a friend, philosopher, and guide to many a person, not just individuals, but to the corporate world as well as to the government of India also in many cases, where you are in the consultative forums, I'm confident that with this kind of an exposure, you relax a lot to learn and unlearn. What you have learned, you perfect it. What you have learned wrongly, you unlearn it today. I am confident this initiative taken by the Institute will take you to a long way to be a great success in the profession. I wish you best of luck. Thank you for your patience hearing. Thank you.
Thank you, ma'am, for your thoughtful and enriching address. We are grateful for your presence today. May I now request Advocate K. Ravi, past Chairman, SIRC of ICA, to kindly share a few words for 2 minutes.
The profile of the Honorable Judge which was read out according to me was incomplete. Therefore, I pleaded for this opportunity. Don't take her to be so simple. I'll give you 2-3 examples. 730 crore or something is the demand. 9th Court Hall, if you remember. K. Parasharan standing for the SSC. First item. He had come to the court at 9:55. 10:30 the court sits. He was going on. I said, sir, what is your tension about? Chitra Varapa, don't take her lightly. She will stump you with some question. And a person of K. Parasharan standing was scared of what she will ask. Of course, what happened in the court is a different thing. He started in less than 2 seconds. The judge, as a judge, she had announced, admit interest, stay. But, he was so anxious about it, I told him, sir, stay, kuduthutta. Then, he understood that, something had happened. Then after her announcement of stay, he was still so conscious of the fact that he has to somewhere protect the client that he said, Lordship should consider a stay. She said, I've ordered it. She had apparently read the bundle. A person of his standing is scared. So don't take her lightly. Her pride she spoke about as a counsel. I think it was the 3rd Court Hall, correct. Builders Association of India. She was the standing counsel for the state. What was then called special government pleader taxes. Am I right? Additional government pleader taxes. She was the additional government pleader. Single-handedly, she destroyed all the SSC's councils. Builders, I think it was argued for more than 3 days by her, if I remember right. She had argued. I'm talking of only one side. And even today, her arguments are accepted in the Supreme Court. She's not as simple as what you see her. Very thorough, very competent. She can also be... I've had the... Shall I say she spoke about women empowerment. Admission matter, I pleaded for an adjournment. He said, no adjournment for admission matters. I had not read the bundle, honestly. I had some other problem that day. He said, no. She said, no. And she does. Normally, for admission matters, she would not give an adjournment. Then I told her, I have a genuine problem. I mean, as a matter of pride also, I must say this. My wife had just then finished her B.Ed in special education and she stood university first, etc. The Vice Chancellor called her that morning and shouted at her for not having paid the fee for the convocation. So I had to do it. I told her, this is the problem, so please excuse me today, we'll have it tomorrow. She said, first finish that and come, and if that is not done, your case is dismissed. I remember those words. Your case is dismissed. Next day when the matter was called, the matter came up next day. She didn't ask about the case. She said, what happened yesterday? I said, I paid the fee. Better learn to respect women. That's the answer I got. My case was admitted. You must also know, as a judge, she's done extraordinary work and don't, I'm 47 VST, you will recall SR shipping. 47 VST, where the concept of permanent establishment, that a ship is permanent establishment, was said by her in a VAT law, correct? 47 VST, if I remember right. So she's contributed extraordinarily well. And where does this come from is what I was always thinking. Her father, V. Balasubramaniam, who was standing counsel for the income tax department. If you take the old ITRs and read some of those judgments where he has been standing counsel, he's contributed significantly to the development of direct tax law. And later on as a judge, he set some of the finest fundamental principles in tax law. And therefore, with great respect, I don't mean any disrespect to you, that it runs in the blood. Law runs in the blood. This unfortunately doesn't get highlighted. I thought it's my duty to bring to your notice all these things. You had an extraordinary person coming this morning to talk to you. Thank you.
Thank you, sir, for the thoughtful words. So, carrying pride in our profession and strengthening our systems were strong messages from the chief guest address. She emphasized the need to study the facts first and then apply the provisions, never the other way around, and to keep the unlearning for continuous growth. These insights were certainly guide us in our professional journey. Thank you. And we will now take a 10-minute tea break. Please reassemble promptly for the next session. Raghunathan and CA Dr. Abhishek Murali, RCM SIRC of ICI, to accompany the speaker, Advocate Sharat Chandran. We now request CA Dr. Abhishek Murali, RCM SIRC of ICI, kindly introduce Advocate Sharat Chandran.
A very, very warm good morning to one and all present here. It's a pleasure to be speaking or be part of the panel which is organizing the program on the Income Tax Appellate Tribunal. Being part of what I should say, my day-to-day routine, the ITAT is a very, very enjoyable experience, but it's also a very specialized experience. But one thing I want to touch upon before I introduce the speaker today is a very important development which has happened. Our previous speaker had touched upon how ITAT members have a lot of chartered accountants. But there was an amendment which was made to the rule appointing a member, an ITAT member, that only if you are a chartered accountant with 25 years of experience, you can become an ITAT member. Imagine having 25 years experience. That means your age will be already close to 50 or 51. And then only you will get appointed as an ITAT member. By that time, you would have already established yourself in practice. Nobody will displace themselves at that stage and go and become a member. Whereas for advocates, it remained still 10 years. Highly unfair. And as already touched upon by our retired Chief Justice, Honorable Chitra Madam, she said, and I agree, and earlier this week also in a session, I categorically stated this. I have studied my law, I have studied CA, I am practicing as a CA. I maintain till this day, I will put my qualifications on the line that chartered accountants are better placed to argue in the tribunals than advocates. So when this amendment was made to the rules, obviously we challenged. Many senior ITAT members who are accountants raised their objections to it. And recently the Supreme Court has passed an order stating that rules have been struck down. You cannot have imparity in this. So now back to the original position with 10 years experience, you can become an ITAT member as well. So anyone who has interest in that field, I implore you, take up this opportunity. Because as of now, the old rules still remain. Hopefully there is no further changes made to the rule. And I think coming to such a meeting should definitely motivate you to take up this opportunity. Now, I have a lot more to share. Maybe I will share it a little later after the speaker. I think he is hurrying to Pune for a session. So I will introduce him as well. Profile of Mr. Sharat Chandran. He is an advocate practicing primarily in Madras High Court. His areas of expertise include commercial law, arbitration, constitution and administrative law, civil and criminal procedure course as well. He has been appointed the amicus curiae by the Madras High Court in several notable cases, graduated economics from MCC with a distinction, bagging the Arjun Jnanavoli scholarship. He pursued his LLB from ILS Pune and he bagged 2 gold medals and was awarded the best outgoing student of the college. He was a hand-picked research assistant of Honorable Chief Justice of India of the Supreme Court and went on to pursue his BCL from University of Oxford, where he obtained a distinction and was awarded the Corpus Christi Book Prize. He has authored many books, including Commentary on Commercial Courts, Concise Commentary on the Bharatiya Saksha Adhyanam 2023, many other books with many leading luminaries. He is also the deputy editor of the Madras Law Journal, Civil, Criminal and Labour, and also contributes to the Kerala Law Journal. I think he is a very erudite speaker at a fairly young age, and we are all looking forward to listening to your session, Mr. Sharath. I welcome you, and it's my pleasure to have you here on this platform. Looking forward to the session. Thank you very much.
Thank you, CA Dr. Abhishek Murali, for the words. So to honor the speaker with us today, I invite Chairperson CA Revathi S. Raghunathan to give memento to Advocate Sharath Chandra. We invite our speaker to give his address.
Thank you, Abhishek, for that introduction, and good afternoon, or should I say good morning to all of you. Justice Chitra Venkatraman was mentioning about the importance of facts. So I thought it's probably better that I take and start from where she left off. The next topic which I propose to take you through for the next hour, an hour and 15 minutes, consists of certain principles of evidence. Now, why is this important to all of you? Justice Chitra Venkatraman said facts are important and you must go hard at the facts. The law of evidence tells you what is to be done with the facts. A whole mass of facts are given to you. Now, what do you do with those facts? I'll give a start with the caveat. It is always said that in administrative proceedings or quasi-judicial proceedings, the law of evidence does not strictly apply. But I will demonstrate to you that like everything, there are no absolutes in either law or life, and there are examples, and I think this is one of them. If you look at the principles, I'll just start with a basic overview of the principles of that act itself. Now, today that is known as the BSA, Bharatiya Saksha Adhiniyam. And if you look at that, it essentially deals, the structure itself is basically common law in codified form. The three most important things which you should just keep in mind when any set of facts is given to you. The first principle is it admissible? The second principle is it relevant? And the third, assuming A and B is satisfied, how do you prove it? Right? These are three elementary things which you should just keep in mind. First, is it admissible? The reason why I'm pointing out to you, whether it doesn't matter whether you're before it, as chartered accountants, you will get cases where a lot of evidence is presented before you. The question is whether is it admissible. There would be objections as to stamp duty. If a certain document is produced, whether it should be impounded, not impounded, questions will arrive. The important thing is it admissible? Which means, can the court receive it? If the court or tribunal is allowed to receive it, then is it relevant? Now, the reason why it is important that you understand these two is, very often there is a lot of facts which a client comes and gives you. Huge mass of facts. The dispute pertains to a particular issue. Now, it is important that you identify and tailor the facts as professionals to suit that particular issue which has to be decided. That is relevancy. Now, in the Old Evidence Act, section 6 to 55 decided what facts are relevant. I'm giving you an example of why this is important, because you cannot rely on evidence of hearsay witnesses. That principle is true whether you are in the court or in the tribunal. A hearsay witness evidence is of no use, right? So these are things which you should just bear in mind. The second aspect is relevancy. Now the third and the most important, and this is where, see, it is said that, as I said, strict rules of evidence do not apply. Now, my submission is that that principle applies only to the aspect of proving, the concept of proof. Strict rules of evidence as regards proof, which is there for a court, do not normally apply to a tribunal. But the basic fundamental principles, who should begin, what are the presumptions, where is the burden of proof, all that is applicable across the board, whether you are in the tribunal or in the court. You can't ask, I'm giving you just an example, and we go into burden of proof in another 5 minutes. Just to give you an example, I assert something. Now, who does the burden of proof lie? On a person who asserts it. Can you ask the person, the other side, to prove the negative? You cannot. So that principle, that where does the burden of proof lie, on whom does the onus of proof lie, is across the board applicable whether you are in a court or in a tribunal. So that's important that we take note of this and also understand that the oft quoted this thing that Evidence Act does not apply is to be taken with a pinch of salt. It is relaxed insofar as proof is concerned, because in the court you will have to, strict rules of evidence apply. The witness will have to come and speak about the document, and the witness will have to state about the contents. All those strict rules of evidence, the rigor of that is taken away. Why? Because it is time consuming. So you are allowed to lead evidence on affidavits. Documents can be marked without there being any witnesses to do so. Those rules have been relaxed to facilitate quicker disposal. That is the objective. But it does not mean that the lock, stock and barrel, the principles have been thrown overboard. Right? So if we understand this, then it becomes easy to understand what applies as we go forward. Now, as regards proof, I just wanted to point out the 4 aspects which the Act touches. The Act basically says what facts may be proved. That is, facts which are admissible and relevant can be proved. What sort of proof is required? So I'm going to come to this because 65B, electronic evidence, all of you know, is a very contentious area. How is a particular electronic record to be proved? And then third, who is to give such proof? And how is such proof to be given? So these are the 4 angles which we will be looking at. Then, the 3 principles, cornerstone principles of evidence. Matters must be confined to facts in issue. Hearsay evidence cannot be admitted. And the best evidence. Now, I'm just saying this because suppose you are having a cell phone and the evidence is available in the phone. The question arises, this is primary evidence. If you take a printout from this, that is secondary evidence, right? So the law requires that primary evidence be given of all things, except in cases where it becomes impracticable. Now, how is it impracticable? I can't give my phone because just because there is one document which is saved in it, I can't say, seize my phone and mark it. That's the end of the phone for you. But so therefore, it's impracticable for me to give it. So the law says, permits you to lead secondary evidence. Take a printout, certify it, file it. So the default principle is best evidence must be given, which is in certain cases relaxed. The next is the most important, according to me, the most important definition in all of the Evidence Act. The definition of the word proved. Now this also applies across the board, irrespective of whether you're in a court or whether you're in a tribunal. What do you mean by the word proved? Now, just look at this because it's an amazing definition. It has stood the test of time for 150 years. Even in the new BNS, they were not able to change it. It only says a fact is said to be proved when, after considering the matters. I am asking to concentrate because it is not after considering the evidence. There could be things outside evidence. Evidence is there, presumptions, burden of proof. The certain laws, for example, GST, you will see, shall presume, may presume, conclusive proof, it would have used at various places. So as a reasonable person, you are asked to say whether he has proved this fact. That is only done when after considering the matters before it, not the evidence before it. So it's wider. The court believes it to exist or considers the existence so probable that a prudent man. So, if I were to say, Madam, if whether this fact exists or not, these are the facts proved, A, B, C, D. Assuming A, B, C, D is proved, do you as a prudent person believe that this fact has been proved? That's the test. Now, this is true whether you are in the tribunal or in the court. The definition of word proved is universal. Now, it has been clarified by the Supreme Court that the rigors of the CPC and the Evidence Act are not applicable to tribunals and quasi-judicial authorities. As I said, that is to say that you do not have to follow the strict rules of putting witnesses in the box, proving documents through them. All that has been relaxed. But we will be looking at certain universal principles which will apply across the board. Then, the BSA, which is the New Evidence Act, applies to all judicial proceedings in or before any court, but not to proceedings before an arbitrator. And so far as quasi-judicial authorities are concerned, they are bound to observe the principles of natural justice. Now, all of you know, if you go to the tribunal or if you go to an arbitrator, same this thing. What is the procedure to be followed? There is no set procedure, right? If you are filing documents, it requires that you serve the other side. The other side is given an opportunity to comment on it, and then you decide. So the basic fundamental rule in any quasi-judicial proceeding is observe natural justice. Do not decide behind the back of any party. Do not decide on adverse material unless it has been put to the other side. Give a reasonable opportunity of hearing. These are all cornerstone principles of natural justice, just to show that that the proceeding is held fairly. Now, coming to burden of proof. This is because one of the topics that I've been asked to speak on is burden of proof insofar as matters concerning the tribunal also. So let's start with the fundamental principle. He who asserts must prove. The principle is in 104 BSA, and the burden of proof lies on the person who is bound to prove the existence of a particular fact. Common sense. I want to avail the benefit of an exemption. I have to establish it. So the base fundamental principles, the reason why I'm pointing out is, time after time we find that some mistakes are committed because the burden of proof is shifted and parties are asked to prove the negative. Now, if I say Ravi sir has got, I have taken his car, and I say I have his car, can he be asked to prove that I do not have his car? No. The negative, you can't ask the person to prove the negative. So therefore, fundamentally, please remember that when it comes to proving something before the tribunal, a person must be asked to prove only, the person who asserts must prove. A person who seeks exemption must establish that he is entitled to the exemption. He must make out a case for that. So never shift the burden of proof on the other person. What is important is that the Evidence Act, as well as, see, the very important thing, and incidentally, Justice Chitra Venkatraman's father had written a very interesting judgment where he explains what is evidentiary burden and legal burden. Now, this is very important because I'll start with a basic thing. The burden of proof is always on the person who asserts. In a criminal case, prosecution is required to prove beyond reasonable doubt. Everybody knows that, right? But the evidentiary burden keeps shifting. Now, I'll give you an example. I've put an example as in the slide. Please have a look at it. To prove a fact that the assessee submits evidence before the AO, then the onus shifts on the AO to disprove the fact by collecting contrary evidence. When contrary evidence is brought on record and confronted to the assessee, then the onus shifts back on the assessee to either supplement the original evidence or counter the evidence by the AO. Thus, the onus is an oscillating obligation, right? So, therefore, evidentiary burden is constant. Legal burden is constant, while the evidentiary burden keeps shifting. It's ambulatory. It depends upon whether somebody gives you material, you can rebut it. After rebutting, he's given an opportunity to rebut. Therefore, burden of the onus of proof keeps shifting. The reason why I'm emphasizing is there is always in the judgment also he says there is always a confusion between burden of proof and onus of proof. People think burden of proof keeps shifting. It can never shift. Burden is constant. Onus is shifting. So, legal burden of proof does not shift. So, I'll give you an example. Let's take a criminal case. I'm just giving you an example, stark example. The prosecution is always required to prove the guilt to the accused beyond reasonable doubt. Everybody knows that. But in certain cases, even in prosecutions under the GST, you will find that there is the mens rea of the accused is presumed. 135. Correct? So, why is that happening? The reason is simple. They all started with an experiment with the Dowry Prohibition Act. 113B was introduced, reversing the onus and saying, where the woman dies within 7 years, it is presumed that the husband had the mens rea. Why was it done? It is difficult to get evidence. It is difficult for them to get evidence as to what happened inside the house. So, to ease the burden of the prosecution, this presumption was brought. So, GST also, mens rea is presumed. And this is this has been extended. PMLA also you find it. And it was challenged and upheld. So, when the mens rea is presumed, the accused has to lead some evidence to rebut it. So, that is the evidentiary burden. The legal burden remains on the prosecution, but mens rea is presumed. So that is the important thing which you need to notice on burden of proof. Then, another that's why I said reverse onus clause. The reverse onus clause, 135 GST, 24 PMLA, all these are provisions where the legislature has reversed the onus and put it on the accused or the assessee. And you need to take note of that, because when you appear for the assessee, you need to lead in some evidence to dislodge the presumption. The standard is only on preponderance of probability. You have to create a doubt. Once you create a doubt, the reverse onus shifts back on the prosecution. But to start with, when they come and say, yes, we have got foundational facts, A, B, C, we have reasons to believe, then the mens rea will automatically be presumed under 135. So, there it is not the burden of proof, it is the onus of proof is shifted to the assessee. So, please remember that, keep it in mind, the distinction between burden and onus of proof. And what normally happens is the normal mistakes we find, at least particularly in criminal prosecutions. The prosecution will file a case saying the offense is presumed to have been committed by the accused. What will happen is, you can really catch them. Please check for example, I'm giving you PMLA. PMLA prosecutions, the onus of proof will apply only if the prosecution establishes a prima facie case of proceeds of crime. As chartered accountants, I'm sure you are all well versed in the new problem. Recently, the Supreme Court quashed a case against the chartered accountant. You must have seen. It was a case from Madras Division Bench. What happened there was, the Division Bench quashed it against the chartered accountant because they were unable to show that there were proceeds of crime. And this argument in 24 was taken, saying that at this stage you cannot quash the prosecution because chartered accountant prima facie has certified. Therefore, he is also liable. There is a presumption that he is also an accomplice, and therefore prosecution should be taken away. What happened was, the Supreme Court said, you are unable to establish prima facie that there is proceeds of crime. If you don't establish proceeds of crime, the jurisdictional fact is not established. Therefore, the presumption will not apply. So, in all cases where reverse onus is sought to be put on you, the easy escape route is to show there is no proceeds of crime, no jurisdictional fact, no presumption, quashed straight away. And that's what has happened in that judgment that the Supreme Court has recently decided. 15 CM, correct.
Pertains to 15 CA, 15 CB that is certified by a chartered accountant.
Chartered accountant, correct. Presumptions. This is another aspect which I thought I should just look at. Now, if you look at the Evidence Act and the BSA, it has three expressions: may presume, shall presume, and conclusive proof. Now, may presume, the tribunal may take into account and presume the existence of such fact. There's some discretion given to the court or tribunal. Shall presume is like the reverse onus cause. You are presumed to be having the requisite mens rea unless and until you lead evidence to rebut it. And third is conclusive proof, for which you cannot. For example, this 269 C2 is where I think the fair market value is 25 times the value shown in the instrument. It is conclusive proof that the transaction is not correct. So you can't lead rebuttal evidence. The section itself says if it is shown that the value of the document is 25 times lesser than the fair market value, then it's conclusive proof that the transaction is bad, and on the face of it bad. So in conclusive proof cases, you cannot even lead evidence to rebut it. Whereas in shall presume cases, the initial this thing is thrown on you, but you are required to lead some evidence and rebut it. So if these expressions you will find in the IT Act, GST Act, PMLA, these expressions, shall presume, conclusive proof, may presume, you will find all over the place, and you will have to read it in this fashion. 22 PMLA, as I said, is record seized during the course of a search shall be presumed to belong to the person concerned. So what happens there? There is a case of it shall be presumed unless the person concerned shows that it does not belong to him. So he can rebut it. Now this 144 of the GST Act is a very interesting provision, because just have a look at it and you will see documents which are produced, seized, or received from any place outside India. I am just telling you why this section is important, because the truth of the contents are presumed, shall presumed to be correct. The signature, attestation and execution are also presumed. Normally it is the other way around. When a document is produced, the witness will get into the box to prove the contents, and the signature and attestation always shall be proved, unless the GST does it turns that provision on its head and says that when a document is produced, its contents shall be presumed to be correct, unless there is a defense taken that it is not correct. Whatever is produced shall be presumed to be correct. There is a presumption on signature, attestation, execution. Why? Because these are the two areas where most likely there will be a defense taken, and the proceedings will never conclude. So the legislature, to hasten the process of adjudication, has introduced these presumptions. Most important thing is, this Stamp Act is a very interesting presumption. Under the Stamp Act, if the document is not stamped as required by law, or is deficiently stamped, it is impounded under 35, as all of you know. Now 144 says it can be received even if it is unstamped or stamped with deficit, and its reception is not barred. And this overrides the Stamp Act because of a non-obstante clause. So we have a case where the legislature has dislodged at least three well-known principles of the normal evidence rule, which is the contents of the document will have to be independently proved. There is a presumption of signature, attestation and execution, and notwithstanding anything contained in this act, stamp objections are not to be entertained. Now this is one of the reasons is because when it comes up, certain documents are produced, you may have seized it, you will produce it. The SSC may take an objection saying it is not stamped properly, you can't look into it. So to dismantle all these defenses, these provisions have been introduced. Another aspect of this burden of proof, this thing is this expression reason to believe. You will see it, yes. Burden of, that's why I said, please understand that it's only a presumption. The onus is thrown on you. The evidentiary burden is thrown on you. That is why it is shall presumed. Otherwise, it's conclusive proof. Shall presume, the court will, by default principle, it shall presume. Unless you lead evidence to show if it is not your document, if the contents of the document are not correct, you produce contra evidence. Burden remains the same. The onus is ambulatory. If you rebut the presumption and say the contents of the document is not correct, it goes back to the department to say that no, this is the correct document. It starts with the presumption that let me give you an example. If the document is seized, the adjudicating authority is given the power to act on the footing that seized document is correct, its contents are correct, its execution is in order, its the signatures found there are all the signatures of the parties to whom it is shown in the document. It is to obviate what is normally taken in civil courts. It is not my signature, its execution is denied, and there is a stamp duty objection. So, at every stage the document will never be coming forward because there will be some bottleneck. So, they have thought it through and knocked it off. Then we come to a very interesting, this reason to believe, which you will find in 67, it's a very nebulous word, one that has caused many rounds of litigation in several. Now, there is some clarity because in the NDPS Act, there is search and seizure just like 67, and then you have this word reason to believe. So, the Supreme Court, while considering the powers of they're not police officers, they're all designated authorities, under the NDPS, had the chance to explain this concept of reason to believe, because you will find this in the Income Tax Act, GST, and it's like the Chancellor's foot jurisdiction. What is reason to believe for A may not be reason to believe for B. So what the law says is now there is some objective criteria. What they have said is reason to believe is not the same thing as suspicion or doubt. And they say seeing is not believing. I think that's a principle of life. I think seeing is not believing. They say seeing also cannot be equated to believing. Reason to believe is a higher level of state of mind. Now, this is very important. Reason to believe is not reason to suspect. It is something higher. Now, what is the meaning of the expression reason to believe? It's not been defined, except in the old IPC in section 26. And it is present section 2 subclause 29. This is the only place where you will see a definition of reason to believe. Now, there, a person is said to have a reason to believe a thing if he has sufficient cause to believe that thing but not otherwise. I'm sure all of you will find it circuitous. I don't think it in a plain reading it makes any sense. So to obviate this difficulty, the Supreme Court in 2015-17 SEC said, wherever a statute provides for reasons to believe, either the reason should appear on the face of the notice, or they must be available on the materials which have been placed before him. So give some objective criteria on the basis of which, now what will happen? This is set out in the notice, so therefore you are in a position to say the officer has got reason to believe for A, B, C, D. Why? Because when you take it up and challenge it, the court will have the benefit of reviewing that. Now, there's one more interesting thing. I think this 132A has knocked off. It says that in the Income Tax Act, I think now there is a recent amendment which was considered in 2017 Supreme Court. It said that reasons to believe cannot be furnished before the state of adjudication. But in 2022-16 SCC 139, the Supreme Court clarified saying, even though you may not give when the notice is challenged, we can call for the file. So in 226 proceedings for certiorari, it is always open to the authority, open to the High Court to call for the file. It is something like preventive detention cases. The court will call for the file, see if there is application of mind by the relevant authorities, and then decide whether reason to believe is only a facade or is there actually some genuine reason to believe. Now, Tofan Singh has made it clear in 2021 4 SEC page 1 that absence of reasons to believe vitiates the search. So, jurisdictional condition is you must have reasons to believe, and that reasons to believe must be objectively set out. Right? Right, now we come to the interesting area, which is electronic evidence, which I'm sure most of you would have some sort of an idea. I just thought I'll take about 5 minutes to just tell you, because to give you a context as to why the law today is, according to me, in a state of confusion. See, originally, most of you would know it as 65A, 65B, right? 65B certificate. Now it is a 63 certificate under BSA. I must give you just a brief background as to where did these provisions actually come from. This 65A and 65B were actually imported from the English Civil Evidence Act of 1968. Now, that act was enacted at a time when computers were largely unknown to mankind. I think only tech-savvy people knew. Judges definitely had no clue about it. So, therefore, 65B was introduced to enable judges to act upon a computer. When a computer produced something, they need to somebody to tell them that this can be acted upon. So they devised a certificate which, if given, could enable the judges to safely act upon, okay, this contrivance has produced something. There is a certificate of a person who is acquainted with that computer. Let them give a certificate, we will act upon that evidence. Devised in 1968. Repealed in 1995. Unfortunately, in 1999, the very same provisions which are repealed in England were introduced in India. Right from the start, we were at least minus 20 years. So, law which was repealed in England was introduced in the Information Technology Act, and I really don't understand why. Because by 1999, computers had already hit the market. People were familiar. So, what happened in England and in Malaysia was, and Singapore, wherever this Evidence Act has percolated, they opened up their law and said, there is a common law presumption that in the absence of evidence to the contrary, courts will presume that a mechanical instrument is in order. So, 1968, you needed a certificate because people didn't know what the computer was. 1999, the presumption shifted to saying, we will presume that what is produced is correct, unless somebody says that it's been tampered. This is the common law principle. In India, we started off in the rear end. We say, no. We will bring the 1968 provision. We will start with the presumption it's not correct. Only if you give a certificate, it is correct. This is the problem. So the very country from which it was imported had gotten rid of it. We introduced it in 1999. Now, this is where you see that there is a problem. I'll take you to the cases in just a minute. But please have a look at this, the provisions. Section 4, the second last, the penultimate one, please look at legal recognition of electronic records. The Information Technology Act of 2000 amended the Evidence Act. It gave legal recognition of electronic records. So please remember, Indian Evidence Act is not the provision of law which gives recognition to an electronic record. Substantive law is Section 4 of the IT Act. Once legal recognition had been done, then that evidence had to be somehow brought in within the folds of the 1872 legislation. Again, another problem, because Stephen had drafted it when pen and pencil were in vogue, physical documents in vogue. How do you get electronic records which is basically intangible, into a tangible definition? Because a definition of document is words written on paper, other instruments, or on some surface, something which is tangible, which can be seen. How do you deal with a document which is not tangible at all? So they thought up this very interesting idea. They introduced a definition of electronic record in the Information Technology Act. Electronic form, that is information kept in that record. Data, which is knowledge or facts kept in a computer resource. And a computer resource is all kinds of databases and computers. These 4 base definitions were introduced in the IT Act. Now, one more thing I want to point out before I go is the GST Act, Section 241, also has a definition of document, and which includes an electronic record. Now, this is the most interesting aspect. Please have a look at the definition in the BSA. it defines documents as including digital and electronic records. Now, here you will have a doubt. What's the difference? What is a digital record and what is an electronic record? Electronic record is defined. Please go back and see section 2T of the IT Act. The IT Act defines electronic record. There is no definition of digital record. What's the distinction? A digital record is something that exists. For example, I use my phone, I create a PDF. I create a PDF which is in the phone. That is a digital record. Now, if I take a printout of it from my phone, it becomes secondary evidence because the primary evidence is the file in the phone. The printout is not an electronic record. The printout is what is known as a computer output. I'm just going to go slow here because I request all of you to just, yes, the distinction between an electronic record, a digital record, and a computer output. Please take a minute to just look at it very, very carefully. Section 63A, 63 of the BSA deals with what is known as a computer output. Now, if you look at 62 of BSA, it says the contents of a electronic record may be proved by the manner contemplated in section 63. Section 63 does not deal with electronic records. The 63 says any information contained in an electronic record which is printed on paper, stored, recorded, copied, pen drive, CD, DVD, etc., or a semiconductor memory which is produced by a computer, or any communication device, or otherwise stored, recorded, or copied. So, if you store, record, or copy derivatively, so I'm just going to tell you again, I have a PDF file in my phone. I can't give my phone because it's far too valuable to me. Therefore, I give a command, print the PDF file and get a paper. Get the PDF converted on paper, right? What do? I convert a digital record into a computer output. And only if I do that, do I have to certify. What do I have to certify? My phone is working correctly, that this PDF was on my phone, there's nothing wrong with my phone, it's just working perfectly well. The usual certification that I have to give under 65B. Why I'm emphasizing this is there's always a confusion as to whether 65B certificate is applicable to the original record. It is not. If you produce the original electronic record, there is no requirement of a 65B certificate, right? For example, I'll give you another example. Theft is committed in the airport. It's caught on candid camera in the airport. It is stored in the airport VC server, a big machine. I have two options. If I have to prove it, I have to dismantle the entire thing and take the server and say, here is the server. It contains the original recording, which is impracticable. So I copy it, right? I copy the thing. I get a certificate from the person supervisor and I produce it. So what happens then? It becomes a computer output and a certificate is necessary. Now, the converse case. A laptop is seized and the digital record, the PDF file is accessed from the computer. The computer is primary evidence. No certificate is required. So, I just request you to please bear in mind the distinction between a digital record, an electronic record, and a computer output. Now the interesting part. Yes. Electronic record is when it is stored in optical, magnetic, or digital media. So, for example, so the distinction will be this: a record which is created primarily by, for example, spreadsheets, etc., is an electronic record. Now, I may have, for example, I'll scan this book, this brochure, PDF it, and put it in my phone. That's a digital record. It's a digital record because it is held digitally in the phone. I will convert the brochure of the ICAI and I will store it as PDF. It becomes a digital record. An electronic record is created and held electronically. This is the basic distinction. And that's why I'm saying it would have all been easier if there was a definition. The legislature has not defined digital record. So various courts are right. In fact, in some courts, they are reading interchangeably. One court has said it is synonymous. It is not. Another court has said that digital record is an erroneous expression. So it stems from a lack of clarity of concepts which are not defined, unfortunately. So it's important that you look it up and bear this in mind, because the Act uses these terms. Why? Now, I'm just going to tell you that because most of you will be dealing with cases where there'll be a dilemma as to how I'm going to produce this kind of evidence before the tribunal. I'm going to give it by way of a certificate. If certificate is not available, what do I do? The whole confusion arose because of certain judgments of the Supreme Court, which, with all due respect, has unnecessarily cluttered the law. And let me just tell you this very simply, because way back in 2003, there was a judgment called Afzal Guru. All of you know Parliament attack case. In the Parliament attack case, one of the crucial pieces of evidence was a call record. Okay. And to prove the call records, operators, the representatives from Airtel were called, asked to get into the box and depose. The objection taken before the Supreme Court was, there is no 65B certificate in this case, so called records become inadmissible in evidence. Since 65B certificate was not given, called records are inadmissible, therefore that portion of the evidence goes, conspiracy fails. Because called records were relied upon to show that the accused were in touch at the relevant point of time to bring them within the net of conspiracy, criminal conspiracy. So if you take out that piece of evidence, criminal conspiracy is gone. So one of the ways he got over it was by saying, it is only, you have two options to prove. You may either produce a certificate, or you may summon the concerned person and prove it. No difficulty. This was the law from 2003 to 2015. 12 years. Thousands of cases were decided on this law. And all of a sudden, in 2014, as is always the case, we have a shocker which comes in. No. Section 63, 65A and 65B are a complete code. Now, I don't understand. I mean, I have always tried to read, and perhaps you all can also read it with me. Just look at 62, which is the old 65A. The contents of electronic records may be proved. Now, my understanding, plain English, is may and not shall. Unless you read, you have seen some statutes shall being construed as may is understandable. But I'm not certain if you have said may can be construed as shall. In Anwar versus Bashir, the Supreme Court read may as shall and said, unless you produce a certificate under 65B, the entire evidence is inadmissible. So the only method of proving a computer output is by producing the 65B certificate, in the absence of which, lock, stock and barrel, the evidence will be thrown out. Now, this created a lot of problems, particularly in criminal cases. Because in criminal cases, the courts were following Afzal Guru. Thousands of convictions have been secured. Many cases where evidence was hard to come by. What were they going to do? So, as is normally the case, Anwar was decided by a 3-judge bench, and somehow 2-judge benches decided to get over Anwar. So they devised ways by which Anwar was to be diluted. The first is the judgment of Justice Bhanumati, and she interestingly said, sitting in another 3-judge bench, this is also a very gruesome case of murder. She said, no, secondary evidence also can be led. So there's nothing wrong in what Afzal Guru said. This judgment was decided after Anwar versus Bashir. So immediately there was a 2 3-judge benches. One 3-judge bench saying 65B is mandatory. Another 3-judge bench saying 65B is optional. Direct conflict. Taking advantage of this direct conflict, one other 2-judge bench said, if you don't raise this objection before the trial court, see what happens normally is, matter reaches an appeal. One judgment comes in our favor. So as lawyers, we normally take it, yes, now the Supreme Court says 65B is not taken. So therefore, in this case also 65B is not required when that matter was decided. When it comes in appeal, it becomes mandatory. So we decided to exploit it, saying the trial court has not let in a certificate under 65B, therefore set aside the conviction. Supreme Court again got about it, saying if you don't raise it before the trial court, you are precluded from raising it because there is an objection relating to proof which can be waived. Then the third and the last judgment was Shafi Mohammed, which went virtually to overrule the Anwar versus Bashir. They said if it's very hard for you to get, you don't get it. We can waive it. Court can waive it in appropriate case. So then what happened was time for showdown number 2, which is Arjun Pandit Rao's case. Now here is where the law was once again considered. Now, incidentally, Justice Nariman was on both benches. He decided Anwar versus Bashir, and he was also a part of this bench. So one of the lawyers said, your lordships may find it appropriate to refer the matter to a constitution bench because there's a conflict. So he simply said, no, this Tommaso Bruno, 2015 7 SCC, is also by a 3-judge bench, could not have laid a law different from what we have said. So therefore we are ignoring it. And thereafter, this is what they have said. When it comes to information contained in an electronic record, admissibility and proof must follow the drill of 65B, which is a special provision on this behalf. Quite obviously, the requisite certification under subsection 4 is unnecessary if the original document itself is produced. This is what I was telling you. If the original itself is before the court, the question of producing a certificate does not arise. It is only in a case where it is an output, right? So I think we've got that. More importantly, what stage can you produce it? Suppose I don't have a certificate. Suppose the man who operated the computer has fallen ill. He's gone on leave for 6 months. Can you produce it thereafter? So to strike a balance, Supreme Court said, till such time the proceedings are not concluded, trial is not over, you can produce it. In criminal cases, it has been held that till such time judgment is written, you can produce it any time. So it is only procedural, and therefore you can produce it at any stage till such time trial is over. Now, what happens to the class of cases where the person is not available, he's dead, or he is not to be found? The person who operated the computer may have left and he must have gone somewhere else. There the court said, in those cases where you have taken efforts to summon that person and he's not there, and he's not to be found, or he's resigned, he's gone somewhere, in those cases we will apply the maxim of lex non cogit ad impo, that you cannot be compelled to perform the impossible. Therefore, the rule is relaxed. So it is only in these cases that so what Arjun Pandit Rao, again, this is the lead decision, 65B certificate is mandatory for a computer output. Without it, the evidence becomes inadmissible and can be produced anytime till the trial is over. And if you can't do it, then only in those cases, it can be relaxed. The BSA, I'll just quickly take a minute to just point out, there is a very interesting development in the BSA. Section 57 is a very important section, and you can just make a note of it. You have cases where a video recording is taken and it is stored in multiple files, right? So you broadcast it, it is stored in server 1, server 2, server 3. All the files are originals. So you can produce any other ones. Then, if it is produced from proper custody, it becomes primary evidence. So what is primary evidence is given in section 57. The second change which they have done is they have introduced a certificate. Now, all of you have must be wondering, there is a certificate required to be produced. What is the format? They have introduced a certificate now as an appendix to the new act, which consists of 2 parts. Now here is the funny thing. The 2 parts are, one is required to be filled in by the person who is certifying, and the other, the schedule part B, has to be filled in by an expert. Now the question is whether, if I am going to take a printout of this brochure from my printer and file it. Why should an expert certify it? What is the expert going to say? Tell me. Now, if you read this act, it says certificate issued by the concerned person and an expert. To add to the confusion, till I think July 2025. Oh, now the second question is, who is an expert? Right? Expert is the only person that is an expert, which is defined as section 39 of the BSA, which in turn refers to section 79 of the IT Act. An expert is the examiner of electronic evidence. Till July 2025, there was no examiner of electronic evidence in Tamil Nadu. So you had a situation where certificate is required, no expert. And so Justice G.R. Swaminathan said in one case, please notify. So the ministry has notified one electronic expert of examiner of electronic evidence for the whole state, which is our forensic science department in Chepauk. For the whole of Tamil Nadu, there is only one expert, which is the forensic science department. The direction was to notify in each district, but that has not been done. But coming back to the certificate, please look at it very practically. If you are going to doubt the authenticity of the electronic record, for example, I say my phone has been tampered. The printout taken from my phone is tampered. If there is an objection to the authenticity, then alone an expert is required, right? Common sense. Otherwise, why would you say that, I am taking a printout from the phone, I am filing the document. Why should it be certified by an expert? It doesn't make any sense. So, some of the courts have interpreted the word and in 65(4) as or. So, they say, if only if the authenticity of the record is questioned, an expert need to be brought in. Otherwise, no. And it makes perfect sense, because otherwise, if you give a requisition to the forensic science department for handwriting, it takes 6 months. So I'm sure no case will go on, because all 65B certificates will have to be signed, countersigned. So it becomes impracticable. Then, insofar as the IT, I'm sure most of you are aware of this, insofar as the Income Tax Department has released a manual, and they provide a very interesting guidance there. They say, electronic evidence alone is not sufficient. Chapter 2.6 of the Digital Evidence Investigation Manual. And efforts have to be made to corroborate the contents by other evidence. This is a very important thing, because otherwise what will happen is they normally take things from the phone without any corroborative evidence and try to make a case out of it. Most important thing which I wanted to point out when I went through that manual is, there is a chain of custody form in the manual. And what is a chain of custody form? Suppose the phone or the computer is seized, and the chain of custody form gives a sequential record of where the phone, how has it been seized, by whom was it seized, when was it seized, what happened thereafter, who handled the instrument, who examined it, who gave an opinion. So it's called a chain of custody form, which is there in chapter 6.4 of the manual. And you must go through it, because if you are able to create some doubts in the chain of custody form, you can hit the authenticity of the record. It's a very important defense area which you can take. And recently, the Madras High Court has taken a view that if you don't collect it and there is a violation of the manual, the search becomes illegal. So possibly an extreme view, with great respect, but something that actually helps some of you who would be defending the SSC. You can just make note of this judgment. Search itself has been held to be illegal. I know, that's why I said it must have gone too far. It's a consequential act, right? The evidence itself goes. Now, 145 is very important. For those of you who have not looked at this, this is the equivalent of 65B in the GST Act. As far as the GST is concerned, a deemed document is also there in as a specific provision. So then what happens is, since a special law is holding the field, the question of applying 63, 62 will not apply because Evidence Act is a general law. As far as GST is concerned, there is a specific provision in 145 which defines a deemed document, and it also requires a certificate under 145(2). Most importantly, fortunately, that certificate does not require an expert. That's because the Act came into in 2017 when the old Evidence Act was in force. So this expert business is not there. So it simply says you will certify it that the computer from which the printout was taken was working fine at all material times. So the 145(2) certificate contemplated in the GST Act does not contemplate an expert, right? So this is one provision which you will have to see, because insofar as the GST Act is concerned, this is the relevant provision for electronic evidence. Now we come to Ravi sir is going here, and I'm going to pull him into this thing. 65B certificate in income tax proceedings. No, wrong decision. There was some confusion as to whether 65B certificate is required for income tax cases. The division bench has taken a view, and Ravi sir was for the appellant, SSC, and sorry, for the respondent. And I believe he told me last time that the matter was stayed by the Supreme Court, and rightly so. I'll tell you why. Because the reason, see, what happened was in LKS's case, the single judge of the Madras High Court took the view 65B is not necessary in adjudication proceedings under the IT Act. Another learned single judge says it applies. So the division bench had two conflicting judgments of two learned single judges. The reason given for not making 65B applicable is that assessment proceedings are not judicial proceedings. Now you apply the logic of the GST Act. Same can be said. Merely the fact that an assessment proceeding is not a judicial proceeding is not a ground to say that 65B certificate is not required. If you remember, 145 also requires a certificate, right? So the basis of the reasoning that this is what I said, Evidence Act does not apply, so 65B is not required. It's a counterproductive argument for two reasons. 65B is made, procedure is made available to fasten to expedite the proof of the record. Simply certify, give, it's over. Otherwise, what do I have to do? You will have to go the normal way, prove it by this thing. It only delays the procedure. So I don't think the easiest way should have been, all right, produce a certificate. No. What would have happened? Instead of that, the division bench took a view saying, the extreme view, that 65B itself does not apply to adjudication proceedings. So this is the view which is presently prevailing. There's an order of status quo, but this is the view which has been taken by the division bench. Now quickly to search and seizure, because we're running short of time. I'll just quickly run through this. Just a word on what is this. See, for example, search and seizure is, the question is whether they violate Article 20. Answer is no. Why? Because a search and seizure does not amount to testimonial compulsion. It is only a seizure of documents or a production of certain things. It does not amount to testimonial compulsion. It does not violate Article 20 subclause 3. The judgment is MP Sharma's case. Now, the recent past, a very interesting judgment has come from the Madras High Court. What is the effect of an unconstitutional search? Now, an unconstitutional search is one where the power of search is abused and is ultra vires the provisions of the Act. Now, what happened in one of the cases was that the search was conducted in violation of certain procedures, and it was disproportionate. It was alleged to be disproportionate because the search continued for days and days. Women folk were harassed, and the complaint was that the fundamental rights under Article 21 was violated, and therefore the search was illegal. Learned single judge of the Madras High Court said, even evidence illegally which is collected is admissible. The old English law, which was basically saying that even if evidence is stolen, it is relevant, it is admissible provided it is relevant. The old law was based on a judgment of the Supreme Court in 1954, which said that there is no right to privacy under the Indian Constitution. And that is why, if you look at Puran Mal in 1974, they said Evidence Act permits relevancy as the only test, and it does not exclude relevant evidence on the ground that it was obtained under an illegal search or seizure. This was the law. 25 years later, you'll have a look at it, how the law had changed. Please see the last sentence of the second paragraph. We say so since the violation of safeguards relating to search would now render a search not just illegal. No, this is not the one. This one. Please look at the last sentence. It does not exclude relevant evidence on the ground that it was obtained under an illegal search or seizure. It will be wrong to invoke the supposed spirit of our Constitution for excluding such evidence. This was in 1974. Fast forward to 2005, where the letter of the Constitution is not clear. We have to keep in mind the spirit of the Constitution. So, 30 years later, the spirit of the Constitution suddenly resurfaced. And 12 years later, in Puttaswamy's case, MP Sharma, which was the basis for the 1974 decision, just going a little slow here because MP Sharma, which is the basis for the 1974 decision, was overruled to say that there exists a right of privacy under the Constitution. Now, once the very basis was altered, the old cases were decided saying a search doesn't matter, let it violate privacy, there is no right to privacy anyway. So even if you collect, it's a search is illegal, material collected is valid provided it is relevant. This is the old law. Now the question was, now that there is a right to privacy under the Constitution, declared by a 9-judge bench, what is the effect of that judgment on the old cases? Very interesting case in this S&J Breweries. This is by Justice Shafiq has authored it. He has taken the division bench has taken a very interesting view, which says that after the judgment in Puttaswamy's case, Puran Mal must be revisited. And therefore, if it is shown in a particular case that the search was unconstitutional, it was disproportionate, it violated Article 20, right to privacy under Article 21, the search and all material connected thereto can become illegal. So the floodgates, that's a good thing, not saying it's a bad thing, but it's a welcome judgment, at least in the standpoint of diluting the old law. The first principle laid down is any violation of statutory and constitutional safeguards during a search which impairs or impinges on the right to privacy may thus have to be examined by applying the doctrine of proportionality. That is to say, if you have disproportionately caused and violated fundamental rights, the result is the action is unconstitutional and which should render the search void. So on facts, you have to demonstrate that the department has overstepped and that this search was not justified. So now there is a window that is opened, and previously you can't do anything. Evidence illegally collected is admissible. Now a window has been granted which enables you to attack the search itself. Now I just had to flag this recent judgment of Madras High Court, which is a very interesting one, where phone tapping, same thing. Phone tapping was held to be unconstitutional, applying the judgment by the division bench. The reason it's a very interesting case because what happened in the case was it was again a trap, and the phone was tapped and they did not comply with the telegraph rules. The question was, okay, assuming I don't comply with the telegraph rules, I have the tapped conversations with me. Even if it is in violation of the telegraph rules, that evidence is admissible because Puran Mal says so. Evidence illegally collected is admissible. But we were able to show that after the judgment in Puttaswamy, if you violate the telegraph rules, is basically nothing but it protects right to privacy in a statutory form. We were able to show that the violation of the telegraph rules means that in this judgment in 1997 has said is that evidence obtained violating the safeguards in the Telegraph Act is unconstitutional and must be destroyed. So these are two decisions which have now given a slightly different complexion, where earlier you can abuse the power of search and seizure, get away with it. Once you get the evidence, the person against whom the evidence is taken cannot even attack the search. But now there is a small window that has been granted by these judgments. So please take note of this. SNJ breweries have actually been remanded by the division bench to the single judge to examine whether the case, whether it is violated on facts, because on facts there was no inquiry. Single judge had followed Puranmal. Puranmal was held not to apply. So it was remanded to decide it in line with Puttasamy. So it's still pending. Another two decisions I think I want to point out. I think we have about 5 minutes. Genesis Enterprises, which is a very, very recently decided case. It's a very interesting judgment of Justice Pratibha Singh. You must read it. The division bench. So, in 67 search, what is the scope and limits to which you can seize electronic footage? They come to your house, they seize materials, and they take the entire footage for what happens in the house, and right to privacy is again triggered. The division bench, the Delhi High Court said, the department can only seize that footage which is relevant for the purposes of the search. You can't simply come and pull out the DVR and go, which contains days and days of footage, some of it may be private, what's happening in the house. So you cannot violate a person's right to privacy. The department can only take footage which is relevant for the purposes of the search. Only that can be copied. That's number one. The second one is that family related footage, which is with the GST department and violates right to privacy, cannot be disseminated in any manner. So safeguards were introduced to say that if the digital evidence is taken and seized, safeguards were introduced to ensure that right to privacy was not violated. So please have a look at this recent judgment of Delhi High Court, which also limits the power of the authorities to take a wholesale this thing. Then, again on 67, we have Arvind Goel's case, which is another, I think it's a CA. And there they came down very hard on the department when he said, you can't use 67 as an asset seizure tool. Come and wipe out the house and go. What they were doing under the CRPC. And you can't use the search mechanism as an operation as a tax recovery mechanism. Now, what is the practical impact of the decision? Again, the purpose of the search must have evidentiary value to the GST proceeding. Not everything can be taken. And cash valuables not forming a part of the stock and trade or lacking GST linkage cannot be retained. Wholesale taking and retaining of assets not permissible. And revenue cannot use its 67 powers as a substitute for Income Tax Act powers. So therefore, again a case where the powers of search and seizure were limited. The reason is very simple. All along from Puranmal's case, experience has taught that search and seizure provisions, repeatedly they were being tested. Repeatedly Puranmal was being cited and said nothing doing. Yes, they have abused their powers. There is no recourse. Sorry. Now the game has changed. The game has changed because the department is now put on guard that should they cross the line, consequences will follow. They cannot take the benefit of Puranmal anymore. We will abuse our powers, you can't do anything. The means must justify the ends. No. Earlier the ends, that principle was not there. As long as the ends where you get the evidence, it doesn't matter. Whether the search was illegal, unconstitutional is not a question at all. So two of these decisions, Genesis Enterprises and Arvind Goel, are cases, and also the judgments which I have shown you of P. Kishore and SNJ breweries, put a restriction on the untrammeled powers of search. They hedge it with limitations. Now it is made subject to right to privacy. At least you have a legal argument, which you did not have before 2017. So I think it's 1 o'clock, so I'm on time. So I think with that, I'll stop because I know that I don't want to spill over. I'll be happy if there are any questions. If 1 or 2 questions we can take, if there are any. It's probably time for lunch. Thank you.
Thank you, sir, for the insightful session. So your clear explanation, burden of proof, the distinction between legal and evidentiary burden, and the principles governing admissibility and relevance of evidence has been truly valuable. So the distinction of digital, electronic and computer records, which helps us understand how each operates, gives us a great clarity to an area that is often misunderstood. So we sincerely appreciate your time and the depth of clarity you brought to this topic. Yes, sir. Over to Mr. K. Ravi, sir.
As usual, Abhishek must have collected his profile from some book and he read it. I'll tell you his profile. He's just now completed revising Mullah on Civil Procedure Code. He wrote the first commentary on the Commercial Courts Act of 2015 in India. He was the first person to write a commentary. And the best part was, he wanted Justice Joseph, as he was then of Supreme Court, to write the foreword. Rohinton Nariman took that manuscript from him and said, I'll write the foreword. He was called by Rohinton to say, you've written an excellent commentary. He is now revising Administrative Law by Sathe. 20 years since the revision was done. He's revised MP Jain on the Constitution of India. Dheeraj Lal, Ratan Lal Dheeraj Lal, who's supposed to be the Bible for evidence, was revised by him. And you know, the other day when I went to invite him along with Revati, I found one book on the latest BNS. I said, what is this? Bailed Out. He said, Ravi, I had some 15 days time to write something. And all this with huge amount of court work. All of you will recall, at least particularly Carnatic musicians should be proud, M.S. Subbalakshmi's case, which was in the Madras High Court. He succeeded before the single judge. He appeared for the grandson to protect her rights. He appeared, he succeeded. When it came before the division bench and the matter was being heard, he almost realized that it is going against him. Even as the judgment was being pronounced in open court, his SLP was ready. That operative portion only he was keying in. This is around 3:30 here. 4 o'clock Supreme Court, it is mentioned saying that this is the order passed by the Madras High Court. I want to stay on it. Judges said, come on Monday. It was a Friday. They said, come on Monday, nothing will happen. Monday morning, stay granted. And he is now examining on this M.S. Subbalakshmi case, what he told me. He's examining whether there can be any rights after the death of a person in terms of so many personal rights. He's trying to examine it so that will. So therefore you ask him, and I must tell you, you can ask him to stop now on this and he's got a flight to catch. Otherwise you ask him to talk on the Malaysian Evidence Act, he will talk. Even that book I saw on his table. How he manages to do all this with the editorship of Madras Law Journal, Civil, Criminal and Labour. I just can't understand, and he's not willing to tell me the truth. I've asked him this question any number of times. I think one of you must ask him how he combines all this in 24 hours. One thing I know is he goes to bed at 1 o'clock and gets up at 6 o'clock, he's on his table. I don't know how he manages, but how does he manage to throw out so much of output, read so much, keep everything in his memory? I think if one of you ask, he will answer. He's not answering me.
Thank you, sir. That was the wonderful information. I now invite CA Dr. Abhishek Murali, RCM SIRC of ICA, to deliver the closing remarks.
Thank you very much, Sharath, for a really, really wonderful address, I must say. And he really covered some very practical aspects which will be affecting chartered accountants without getting too technical. It's a really, wonderful presentation. In fact, when we see some of the judgments he discussed of how judges are changing, like he said, spirit of constitution was rediscovered 20 years later. That was a very, very interesting thing. I'm reminded of this story. A person goes for a shooting class. So he goes to the coach and he says, teach me shooting. He says, you are new over here. You just practice. I need to go out of station. 1 week I'm traveling. You just practice shooting. So that boy, he is practicing whatever. Coach comes back after a week. 1 week later, he is back. and he sees every shot made by this boy is bullseye. Every single shot is bullseye. So then he calls all the students, everyone, he assembles them, he gives a standing ovation. He says, we have got a person who is going to represent us in the Olympics. He'll win gold medal. And 1 week I was out of town. Without that coaching itself he has done. So please tell me how you did this. Please teach us also. He said, nothing, sir. I was seeing everyone drew the circles and then they shot. But I shot first and then I drew the circles around it. So like that, some of the strategies which are planned, I thought only advocates do it, but even the judges seems to be doing it based on the decisions that he discussed. And generally they say when it comes to advocacy, if you are strong with the facts, bang on the facts. If you are strong with law, bang on the law. If you are not strong with either, bang on the table, you will win the case. And they also say the person goes, he says, I want advice. You know, I have 2 cases. This is the background of the first case, who I should go to. He says, you go to Mr. X. He's a good lawyer. And then he says, sir, I have another case. You know, these are the background of the case. He says, you go to Mr. Y. He's a great lawyer. He said, sir, what is the difference between good lawyer and a great lawyer? He says, a good lawyer knows the law. A great lawyer knows the judge. So, but Sharath here knows the law and the judge, and clearly he is also involved extensively in the drafting of it. I must say, his credentials are really something wonderful, and the delivery of the presentation that he gave today was equally enthralling. Thank you so much for your very valuable time, Sharath, and thank you all for a very patient listening. I think we're breaking for lunch now, so we'll break for lunch and then we'll return.
For 30 minutes. So please enjoy your meal and reassemble in the hall promptly after the break. Thank you.
Thank you very much.
G-Stat. We are honored to invite the 2 presiding officers for the moot court session, Mr. N.V. Vasudevan, former Vice President of the Income Tax Appellate Tribunal, and C.A.B. Ramakrishnan, Designated Partner, Regulatory Compliance and Taxation, CNGSN and Associates LLP Chartered Accountants. So we request both dignitaries to kindly take their places and preside over the moot court proceedings. N.V. Vasudevan, Advocate, former Vice President, Income Tax Appellate Tribunal. Shri N.V. Vasudevan completed his basic education in Chennai. He holds BCom from the University of Madras, D.G. Vaishnav College, and degrees in General Laws and Law from Madras Law College. He is a member of the Institute of Company Secretaries of India. He enrolled as an advocate with the Bar Council of Tamil Nadu and Pondicherry. He practiced for about 17 years, primarily handling civil matters before the Madras High Court and subordinate courts. Post-retirement, he has resumed practice as an advocate, focusing on income tax advisory, civil law consultancy, real estate and succession matter. Mr. B. Ramakrishnan is a graduate of Madras University and a fellow member of ICI, as well as a graduate member of ICAI, with ranks at both university and CA interlevels. He has been in professional practice since 1991 with over 30 years of experience in handling direct tax appeals up to the tribunal stage. He heads the regulatory compliance and litigation practice at his firm, specializing in complex tax disputes. His cases are widely published in top tax journals, including top 100 income tax rulings, and he frequently briefs senior advocates in matters before the High Court and Supreme Court. To honor the presiding officer, I invite Chairperson CA Revathi S. Raghunathan to give memento to Mr. N.V. Vasudevan, former Vice President of the ITAT, and C.A.B. Ramakrishnan, Designated Partner Regulatory, by Abhishek Murali, CA. Request Abhishek Murali to give the memento. Thank you, sir. I invite N.V. Vasudevan, former Vice President of the ITAT, to deliver his address on moot court proceedings.
Good afternoon, everybody. Today we have assembled in this session to have a feel of how the Income Tax Appellate Tribunal functions. See, these slides I have made, about 20 slides. And the slides have been made keeping in mind that the audience here are not exposed much to the tribunal work. So with this caveat, let me start the slides. Basically, there are two legal systems, both adversarial and inquisitorial systems. In the adversarial system, the parties to the litigation, they play a very active role. That is, they procure the evidence and place it before the court and make out a case for the clients. The judge plays a very neutral role. His role is confined only to ensuring that the procedures are properly followed. In the inquisitorial system, the judge plays a very active role. The lawyers play a very passive role. The idea in inquisitorial system is for the judge to find out the truth. The courts in India follow the adversarial system. In so far as the proceedings before the Income Tax Appellate Tribunal is concerned, it is neither adversarial nor inquisitorial in nature. Though it leans more in favor of the adversarial system in the sense that it is for the assessee to place all material facts before the tribunal, which will enable him to get the relief. Ultimately, the principle which governs the decision in all tax proceedings is Article 265, which says that there shall be no tax without the authority of law. Therefore, a tax liability in the absence of backing of a statutory provision cannot be sustained. These all the three principles are kept in mind by the tribunal in deciding cases. The Income Tax Appellate Tribunal was created under the Income Tax Act of 1922 with effect from 25th January 1941. Under the 1961 Act, the provisions relating to Income Tax Appellate Tribunal are contained in 252 to 255. And there is an Income Tax Appellate Tribunal Rules of 1963 which lays down the procedure in Income Tax Appellate Tribunal. Income Tax Appellate Tribunal is a quasi-judicial institution, which means that it has all the trappings of a court, but it is not a court. The motto of the ITAT is speed, inexpensive and impartial justice. The very important aspect of the tribunal is the informal atmosphere, transparency, that is open court hearing, and combined with expertise of members from the field of law, accountancy and tax administration. So this expertise gives an edge to the tribunal. Invariably, you will find the expertise in the field of law is lacking at the assessment and the first appellate stage. Then this tribunal in Supreme Court in V.K. Agrawal's case has held that tribunal is a court for the purpose of Contempt of Courts Act, and therefore the tribunal's dignity and authority has been affirmed by the Supreme Court. It's a final fact-finding authority. On facts, the decision of the tribunal will be final. The only ground on which you can challenge the findings of facts for the higher forum is on the ground that the findings of the tribunal are perverse. Therefore, as a professional, the first thing which all of you should keep in mind is that the factual details should be brought on record properly, in the sense you have to lay all the evidence in support of the assay's case. If you miss the bus at the tribunal level, things will be very difficult. Then, in the filing of appeals, the first thing that happens is some assessee comes to you for filing an appeal. You notice that there is a time limit for filing appeals. It is 60 days from the end of the month in which the order is received by your client. If you fail to file it within 60 days, you have a right to file an application for condonation of delay. Condonation of delay is not a matter of right. You have to make out a case that there was a sufficient cause for the delay in filing the appeal, and you have to explain each day's delay. So it's better that you sensitize the client about the necessity of filing the appeal well in time so that you can avoid complications. Then you file the appeal in Form 36 in triplicate, and you have to annex 2 copies of the order appealed against, and one must be a certified copy, 2 copies of the order of the assessing officer, the grounds of appeal and statement of facts that were filed before the commissioner, challan for payment of fees, 2 copies of the relevant assessment order if the appeal is against a penalty order, then 2 copies of any other documents or submissions previously filed during the income tax proceedings that the appellant wishes to rely on. Then appeal fees, assessed income up to 1,500,000, 1,00,000 to 2,00,000, 1,500, above 2,00,000, 1% of the assessed income up to a maximum of 10,000. Any other matter, rupees 500, miscellaneous application, rupees 50. Then you need to get a power of attorney from the client when you accept the brief, and you have to ensure that the person who is giving you the power is authorized to sign the memorandum of appeal in terms of Rule 45 read with Section 140 of the Act. I think many of you will be very familiar. Individual by the individual himself, HUF by the Karta, where he is absent from India, adult member of the family, company with the managing director, or if there is no managing director, any director thereof. Here, if there is no managing director, you may need to file an affidavit to the effect that the company does not have a managing director. Then the firm by the managing partner or any partner, LLP, designated partner, or any partner, local authority by the principal officer, AOP, member of the AOP or principal officer, by the power of attorney in the case of non-resident company, government managed company, principal officer, political party, chief executive officer of such party. Then whom do you make as a respondent in the appeal? The respondent will be the first appellate authority who passed the order. And in the case of order challenging and passed under 263, the concerned commissioner will have to be made the party. Then when you file the appeal, the registry will give you a date on the date on which you file it. That is a practice now presently prevailing. They give you a defect memo wherever there is a defect, and it is up to you to rectify the defects and also keep a track of the dates of hearing. And in case you miss out on the dates of hearing, you can go to the website ITAT NICIN and you will get the dates. Then once you file the appeal, before filing the appeal, you have to settle the grounds of appeal. Rule 8 of the Appellate Tribunal rules that requires every memorandum of appeal to be written in English and shall set forth concisely under distinct heads the grounds of appeal without any argument or narrative. Such grounds shall be numbered consecutively. I mean, to give a practical example, let's assume there are 3 additions made by the assessing officer and you are challenging all the confirmed by the commissioner. You want to challenge all the 3 additions. You have to separately have a ground for each of the additions. You can't club all the 3 and say that this addition should be deleted. All the 3 additions should be deleted. You have to be very specific. For example, let's assume it's an addition under Section 68. You must say that the SSE has satisfactorily explained, or some other grounds on which the commissioner has not accepted your case. You have to challenge that. So that is the way you have to group all the grounds, and you have to group it according to the issues. The Rule 11 says that if you don't raise a ground, you cannot argue on that point. So in such a situation, you find that you have not raised a particular ground, then you have a right to file an application for raising an additional ground. You have to give the reasons why you had not raised these grounds in the earlier grounds of appeal. then you get a engagement to appear in a case filed by the department against your assessee. You have to get a power of attorney from the client. The power of attorney has to be signed by the same person, which I mentioned earlier, Rule 45. Then you have to read the grounds of appeal, and you have to take a call whether you need to file a cross appeal. That is, let's assume that the commissioner decides one or two grounds in your favor and the third ground against you. The department challenges the order of the commissioner on the ground on which assessee was given relief. In that appeal, instead of filing a cross appeal, you can also file a cross objection. In the cross objection, you can say that these two additions which are sustained by the commissioner should also be deleted. The cross objection, you can't file a cross objection just mere supporting the order of the commissioner. Then you have a paper book. A paper book is a very important aspect in the appeal. Rule 18 of the rules, ITAT rules, you want to rely on a document or statement or other papers, you need to file a paper book, and you have to initial each page of the paper book. You should make an index of the papers which you are filing, and you must number the paper book in serial order. If there is any document which is not in English language, you are supposed to file a true translation of that document in English. See, you have to be very careful when you certify the papers in the paper book. Invariably, it turns out that you may, in a hurry, file the wrong paper and certify it as true. So please, you have to take proper care, because there are consequences if you certify a paper as true when it is not really true. Then the appeal comes up for hearing. Then the first thing you should do is that please check again whether the PO is on the record, power of attorney, because invariably what happens, the bench will first question is, have you filed a power of attorney? That's the question they will ask. Then you can prepare a synopsis of each of the issues, 4 or 5 issues. Make a synopsis of on each of the issues. And if you raise a general ground, you can all tell the court that this is a general ground. Because usually what happens, the first ground is that order of the commissioner is illegal, unsustainable in law. So that's the general ground. So you can say this is a general ground and go to the specific grounds. And then when you address the court, you need to be very courteous and respectful. The strength of your case does not depend on the volume at which you speak. You are expected to speak in a very average tone, neither too low nor too high. If you rely on a case law, you furnish a copy to the bench as well as to the other side. You can even give a list of cases to the other side, but well in advance, so that they can read it and be prepared to answer those case laws. It's better that you bring the assessee to the court, because factually there could be some issues on which the bench may need clarification. So the assessee will be the best person to clarify, but if you have handled it right from the beginning, you will be able to manage. But if you are handling it at a later stage of the proceedings, you need to better to bring the assessee and get things clarified. So you find a very difficult situation in the court, you are not in a position to further proceed. You can always ask for a date and tell the court that I need to work on this particular proposition, please give me a date. But you should do it without any intention to skip a particular bench. The order in which the arguments are advanced in the tribunal is that firstly the appellant will set forth his case, he will address arguments, followed by a reply by the respondent, and then the appellant will get a chance to clarify the points that were argued by the respondent. A reply to the rejoinder is not generally permitted, but it's the discretion of the court. In certain situations, the court might permit you to give a reply to the rejoinder. Very important thing is the court generally after conclusion of the hearing, they will say heard. Once the case is heard, that's all. That is the end of the matter. You can't do anything beyond that. That is the last stage at which you can tell the court anything you want to say. So before that, you have to make all the points you want to do it. And this, it's very important to keep yourself updated on the latest position of law, because in income tax matters, you have to be on a day-to-day basis, you have to be in touch with the judicial pronouncements. I think Taxman, Walters, Clover, these are all good websites which give you the latest position. And more than anything, the case laws, the articles in these journals are very good. And more important is that your interaction with the counsels who regularly appear before the bench, they may be in a position to give you the latest case law on a particular point. Then there is a dress regulation for male representatives, suit with a tie, a buttoned-up coat, or a pant or national dress. And then for a female representative, black coat or white, any other sober-colored sarees. And in case you are appearing in a case which was already filed by somebody, you are expected to file a fresh power of attorney together with an NOC from the earlier counsel. See, general rule with regard to production of evidence is that you have a chance to file the evidence only before the assessing officer. Before the first appellate authority, there is a procedure for filing additional evidence, Rule 46A. And if you miss the bus, probably at the stage of tribunal, it will be very difficult for you to let in any fresh evidence, because Rule 29, it is the discretion of the tribunal to accept or not to accept additional evidence. So, additional evidence, the court must be convinced that the evidence which you seek to file is very relevant for a decision in the case, on any substantial cause, or you didn't have a proper opportunity before the lower authorities. And the reasons why they are permitting additional evidence should also be recorded in the order. So this is a very important, there one more chance you have to produce, to clarify things on facts in the form of additional evidence before the tribunal. And then adjournments, you have to file the adjournments well in advance before the date of hearing and file a copy of the DR's office. Invariably, adjournments would be granted, but it is important that you make some arrangements for somebody to be present in the court for seeking adjournments. Then suppose there is a death, you have to bring on record legal heirs. There is a change of name or merger, you have to file revised form 36. And then you have a code of ethics which has been reported in the All India Federation of Tax Practitioners. You can just have a cursory glance so that you will get a rough idea of how to go about things in the tribunal. There is also a 1951 guidance by the registrar of the ITAT that may also be looked into. I think I've just tried to give you a very basic information on how to proceed with the tribunal. Ultimately, I have to tell you that unless you slog and go to the tribunal on a regular basis, is preferably if you have a case, at least a week in advance, you can go and have a look at the proceedings and how it happens. That will definitely give you a very good idea how to present your case. Thank you for a patient hearing.
Thank you, sir, for explaining the process in detail. So now we invite our counsels to the dais. Mr. C.A. Vaish. So I'll hand over the proceedings to Mr. Vignesh. So before we begin the proceedings, I have a few important instructions. There will be no separate summing up sessions. The presiding officer will summarize key points at the end of each case. All participants are requested to only observe the proceedings. Please do not interrupt, ask questions, or raise doubts during the arguments. We also introduce the court master, Mr. Vignesh, for today's session, who will call the matters listed for hearing.
The first case listed for the day, Mr. Ramanathan. For counsel, Mr. C.A. Yashwant. For DR, C.A.N. Arjun Raj.
Appear for the respondents.
May I please, Your Honours? Your Honours, the assessee is an individual and the assessment year involved in the appeal is assessment year 12-13, Your Honours. The assessee during the impugned assessment year has sold a property for a consideration of 1.02 crores. And the long-term capital gain on account of sale was counted as 82.96 lakh, Your Honours. The property sold by the appellant was purchased by the father and mother of the appellant, which was transferred to the appellant through a partnership, through a gift deed in the year 2006. Thereafter, the assessee filed the return of income by claiming indexation as on the previous cost to the previous owner and computed indexation at 1980 cost. Based on the long-term capital gain, the assessee has invested in purchase of a residential flat. The contention before this honorable tribunal is the assessing officer has come up with few observations which were withheld by the first appellate authority, that is by the Commissioner of Income Tax Appeals as well, Your Honours. So I'll just bring out the facts before as to what all the things which the assessing officer has disallowed in this appeal. The first thing is the contention of the assessing officer is that the assessee has not invested the long-term capital gain, has not invested the sale consideration in his long-term capital gain account. Then thereafter, this second thing is the assessee during the year has purchased a plot of land, but in connection with that he has not constructed it. So the benefit of 54 has to be denied. The third thing is the indexation benefit has to be given only from the year in which it was transferred to the appellant. The fourth thing was there were flats which were purchased, 2 flats, but having a common entrance. So the contention of the assessing officer is that only 1 flat at best may be given to the assessee. Then the property which was subsequently purchased by the appellant is in the name of the appellant as well as in the name of his wife. So these are the observations wherein the assessing officer has arrived at the assessment. Your Honours, first thing, the observation that 54(2) has not been complied with by the assessee. I would like to bring forth the provisions of section 54(1) of the Income Tax Act, which states that I'll just read out the relevant portion, not the whole of it, Your Honours. The income of 54(1) line number 4, Your Honours, the income of which is chargeable under the head income from other sources, and the assessee within a period of 1 year before or 2 years after the date on which the transfer took place, purchased, or within the period of 3 years after that date, constructed 1 residential house in India, then instead of capital gain being charged to income tax as income of the previous year in which the transfer took place, it shall be dealt with in accordance with the following provisions of this Act. Your Honours, as pointed out in the facts of the case, the assessee during the year has subsequently purchased a flat in via sale deed dated 31/10/2014, Your Honours, which is within 2 years, Your Honours. So what we are trying to say, what the assessee was trying to rely upon is the fact that 54(1) has been complied with. then subsequently the provisions of 54(2) should not have any binding on whether the deduction has to be allowed or not, Your Honors. So, since the 54(1) has been complied with, the 54(2), as said by the assessing officer that the provisions has not been fulfilled, will not withstand, Your Honors. Then the second issue which... So do you have any decision to support this? Yes, Your Honors, I have decisions. There is a jurisdictional high court in the case of Venkata Dilip Kumar versus CIT, Your Honors. And then there is a Chennai tribunal in the case of Krishnamurthy Venkat Raghavan. And there is a Bangalore tribunal, Ramaya Doriraj versus ITO, which is passed by this honorable judicial member. Can you read the operative portion of the Madras High Court? Yes, Your Honors. Your Honors, page number 6 of the case law book, para 14, Your Honors. In my considered view, the contention of the revenue to deny the benefit of deduction to the petitioner/assessee cannot be justified for the following reasons. Section 52(4) cannot be read in isolation, and on the other hand, application of section 54(2) should take place only when the assessee failed to satisfy the requirements under section 54(1). While the compliance of requirements under 54(1) is mandatory, and if complied, has to be construed as substantial compliance to grant the benefit of deduction. The compliance of requirement under 54(2) could be treated only as directory in nature.
You can go to the next point.
Your Honor, the second issue is that during the impugned year, the assessee has purchased a plot of land but has not constructed the same on that part of land. But the assessing officer failed to appreciate that there was a flat which was purchased within the given period of 2 years by the assessee. So the section itself clearly states that if the plot, that is, if the flat has been constructed, the residential house has been a residential property, no, a residential house as such is constructed within a period of 2 years, then the assessee is eligible for 54. So the contention of the assessee contention of the assessing officer will not withstand, Your Honors. Thereafter, the assessing officer has given me the indexation benefit only from the assessment year 2005-06, whereas at the time of computation, the assessee has computed based on 1980, Your Honors. What we would like to rely on is the provisions of section 49(1), which clearly states as follows. Cost of reference with certain modes of acquisition. 49(1), where the capital asset becomes the property of the assessee. Subclause 1, on distribution of asset on the total or partial partition of the Hindu undivided family. 2 is under a gift or will. As pointed out in the facts of the case, it was the assessee has received it through gifts. So it will get covered under 49(1). And the conclusion is the cost of acquisition of the asset shall be deemed to be cost for which the previous owner of the property acquired it, as increased by the cost of any improvement of the asset incurred or borne by the previous owner of the assessee, as the case may be. So it is clear that as per the provisions of 49(1), the assessee is entitled for indexation from 1981. I would like to rely on the decision of CIT versus Manjula J. Shah, Bombay High Court, followed by the jurisdictional High Court in the case of CIT versus Saroja Naidu and CIT versus Shanti Chandran. The next contention is that the contention of the assessing officer is that the assessee has purchased 2 flats, and even though it has a common entrance, but still it is 2. So the assessee will not be eligible for deduction under 54 for both the flats.
How do you establish that the 2 flats are actually only 1 flat?
Your Honors, the terminology which is used in 54 is it should be a residential house. It should not be considered as a residential unit. Each unit should not be taken up as a separate unit. It is the house in which the assessee will be staying, and then out of the sale proceeds, the same is being purchased. No, Your Honor. Even in the document, there have been 2 flats, but it has been allotted a single number. How do you establish that it is a single unit? Is there any evidence of an engineer, or have you done any survey? Your call the assessing officer to the spot to verify whether it is a single unit or 2 different distinct flats? Your Honor, during the course of assessment, the assessing officer has directed the inspector to visit the property. He had a look into the property and he has come to a conclusion that there was only one kitchen in the premises, even though the house has been constructed in such a way that it can be considered as 2 flats, but it is only one flat which is having only one kitchen. Yes, Your Honor. So the inspector has accepted that it is only one. It is only one, and then the fact that it was being constructed in such a way, the assessing officer doesn't want it to accept, Your Honor. Yes, Your Honor, it is filed. On that, I would like to rely on the Mumbai tribunal in the case of Nakul versus ACIT. In ITO, Sarojini, the Kolkata tribunal in the case of ITO versus Sarojini Rani Gupta, then Cuttack tribunal and the Madras tribunal as well, Your Honors. Then the final issue is that the property purchased by the assessee was in the joint name along with his wife. In this, we would like to rely on the jurisdictional high court in the case of CIT versus Natarajan, wherein it was held that even if the property was purchased in the name of the wife, out of the consideration by the assessee, it will be assessed as property of the assessee, but the deduction under 54 will be eligible. No, Your Honors, only for the practical purpose that if any uncertainty happens in future, just to make sure that the wife doesn't come across any difficulty, the name of the wife has been included in the deed, Your Honor. Yes, Your Honors, the consideration in toto is being paid only by the husband, just for security or say via. Yes, Your Honors, all the details were filed during the course of proceedings, Your Honors. So in that, as we relied on the jurisdictional high court, it was held that the assessee is eligible to claim deduction, Your Honors. Yes, sir, I rest my...
May I please, Your Lordship? Lordship, before I begin my arguments, I'd like to just give a brief background on the dates and events to establish the facts, Lordship, to also appreciate the contention of the revenue in not granting exemption under Section 54, Lordship. Lordship, in the screen that is visible now, the dates are starts from 1980, Lordship. The original asset was purchased in the year 1980 by the parents of the assessee. 2006, it was gifted to the assessee, Lordship. And in 2013, the original asset has been sold by the assessee. That is on 7th February 2013. Lordship, there is another important crucial fact which is coming out from the facts captured in the assessment order is that in 30th March 2013, the assessee has purchased a site using the sale proceeds, but he could not construct the building in that particular site. For that reason, he has, after the due date under 139(1), that is at row number 5, which is 31/10/2013, after the due date, he had purchased 2 residential houses for rupees 96 lakhs on 31st October 2014, Lordship. The first point which I'd like to highlight is that first, there was an attempt to buy a site and construct. For some reason, they couldn't execute it, but the site was purchased. And after that, they have purchased 2 flats for which exemption has been claimed under Section 54, Lordship.
Is there any prohibition in the law that you should not attempt to do something? And,
Lordship, the department cannot find any offense for doing anything, Lordship, because it is not within their domain. But what we can do is that whether the exemption which has to be granted has been scrupulously followed. The conditions in relation to has been scrupulously followed or not.
the new asset.
Yes, yes.
But you attempt to comply with the law, but you give up the attempt and you comply with the law in a different form.
Precisely, yes.
How can the attempt be a ground to disallow the actual investment?
Lordship, the attempt is not being disputed now. Now, what they have claimed is row number 6, the purchase of 2 houses. But what the department is contending is that in row number 6, when they have to be entitled for an exemption under the new house which they have purchased now, the other conditions under 54, whether it has been completed or not, is our contention, Lordship. To substantiate that, one second, Lordship, I think some technical issue. So, the conditions which they have violated. Now, I would like to counter the 4 issues which has been raised by a learned friend also. First issue is whether they complied with the provisions of the Act. Lordship, in 54, the main contention of the AO is that he has not complied with 54 subsection 2, Lordship. Lordship, before I read the section and the conditions, the main purpose of this 54.2, this was introduced through the Finance Act 1987, Lordship. The purpose is that most of the times when the assessing officer takes up the scrutiny for assessment, the 2-year or 3-year time limit is not over. So he could not visualize whether the asset has complied with the conditions, whether the new asset was created or not. For this purpose, to identify and monitor the new asset being created, the legislature wanted to introduce this 54 subsection 2, wherein they wanted to introduce this capital gains account scheme through which the money is being monitored. So the assessing officer has control over the funds, the sale proceeds which has been received and which has been utilized towards creation of the new asset. Actually, there are 2 prerequisites. One, assuming he is not able to identify an asset within 139(1) time limit for filing the return of income, he is supposed to deposit into a capital gains account scheme, and it has to be from the capital gain account scheme, it has to be utilized within the 2-year or 3-year period as the case may be. In this case, Your Lordship, it's an undisputed fact that it was not deposited in the capital gains account scheme. And it's an undisputed fact that initially the funds were used for purchasing a site, and then a new 2 houses has been purchased. Now the 2 questions arises before Your Honors. One, is there any condition of direct nexus to be brought out for the sale proceeds and the reinvestment being made? Second, whether it has to be routed only through the capital gains account scheme. According to the assessing officer, Lordship, both the conditions are mandatory and has to be satisfied in order to be entitled to 54(2). My friend had also pointed out the decision of the Madras High Court, Lordship, in the case of Venkata Dilip Kumar. Lordship, the judicial president, before I read the Madras High Court, I would like to, in fact, the Madras High Court draws its strength from the Karnataka High Court, Lordship, in the case of K. Ramachandra Rao, where they have held that as long as it is complied within 139(4), because the Act does not say 139(1). The section also, Lordship, clearly says 139. So the Madras High, the Karnataka High Court initially had interpreted saying, if it is complied within 139(4), then the assessee would be entitled for 54. This is the decision which the Madras High Court also in the case of Venkata Dilip Kumar draws strength for allowing, Lordship. But there is another interesting development, Lordship, in that aspect. There is a subsequent Bombay High Court decision after the Karnataka High Court in the year 2016 in the case of Humayun Suleiman Merchant. Lordship, I would like to refer to relevant portions of the judgment where they say it should be strictly construed, and the view taken by the Karnataka High Court, they wanted to differ with the view taken by the Karnataka High Court, Lordship. Lordship, the relevant portion, even in this case, they refer to the intent in which it was introduced. The 1987 Finance Act and other things are brought out. In fact, the counsel appearing for the assessee had relied on the Karnataka decision in the case of Ramachandra Rao. But the revenue, and in fact, the Honorable High Court, Lordship, they wanted to differ with the view taken by the Karnataka High Court.
Madras High Court is in favor.
Lordship, I just another 10 minutes, I'm not more than 2 minutes. I'll address the Madras High Court also. The reason why I'm still waiting this, Bombay High Court, after this, Lordship, the Madras High Court, my friend is referring to, is a single judge decision. That has been challenged in writ appeal. There is also a writ appeal order, Lordship. I'll just refer to the findings of the writ appeal order. That is the reason I wanted to address the Bombay High Court first and then take your honors to the Madras High Court.
When the Madras High Court is on the point.
On the point, Lordship, it has been diluted in the writ appeal, Lordship. Lordship may give me just 2 minutes. I'll clarify that point also. Lordship, the screen is visible. Lordship, at para O, the council had relied on the Karnataka High Court decision in the case of Ramachandra Rao, where an identical issue was considered. Lordship, this is crucial, Lordship. Lordship, at para S, it is settled position in law that no occasion to give a beneficial construction to a statute can arise when there is no ambiguity in the provision of law, which is subject to interpretation. They have followed a Supreme Court decision and say it should be construed strictly and 54(2) should be applied strictly. Lordship, this is the Venkata Dilip Kumar decision my friend is referring to, a single judge decision dated 5th November 2019. If you're on the identical point, Lordship, with the 54(2), this is where they rely on Karnataka High Court, Lordship. Lordship, the reason why I took your honors to Bombay High Court is that what happened, Lordship, this finding at para 17, which has been relayed by the assessee, is challenged before the writ appeal, before the division bench, Lordship. And division bench, Lordship, on order dated 15th October 2020, had rendered certain findings, but the findings are very interesting, Lordship. I can't say whether I've succeeded or lost, but the findings are very interesting, Lordship. What happened, Lordship, in that case, the FA giving order has already been passed in the case of Venkata Dilip Kumar. And writ appeal was challenged by the revenue before the division bench. And the Honorable Madras High Court, Lordship, at para 7, if your honors notice, the revenue sought to distinguish the distance in the case of Ramachandra Rao.
Shows the operative portion.
Yes.
Or we'll ask the council for the assessee to reply on this.
The para 19, Lordship, I'll just read para 19. Therefore, in our considered view, revenue cannot pursue this appeal after implementing the order in the writ petition. However, we take note of the argument of Prabhu Mukund, learned and so on so, with regard to the legal issue, which has been decided by the writ court by following the decision of K. Ramachandra Rao. On that issue, Lordship, this is crucial. We are of the prima facie view that findings rendered in Humayun Sulaiman Merchant, which is the Bombay High Court which I relied upon, appears to reflect the correct portion of law.
So it's a case where operation is successful with the patient.
Patient is but they have not answered the question of law, but they have given a specific finding saying prima facie we agree with the decision taken by the Bombay High Court in the case of Humayun, Lordship. If that is the case, Lordship, my humble submission, Madras High Court is in my favor, where they have agreed and concurred with the Bombay High Court, and the action taken by the assessing officer in denying 54 is correct, Lordship. This is on the first preliminary issue. Assuming this issue is decided in my favor, Lordship, the other multiple houses, other issues will become academic. But for the sake of completion of argument, Lordship, in multiple houses, I'll just make one submission, Lordship. I think there are two other issues raised with respect to this 54 claim, Lordship. The first issue was in the name of wife. Lordship, in that context, there is a recent Bombay High Court decision which I have also placed on record in paper book. I don't want to trouble you, honest, with the relevant findings, where in the case of Prakash, Bombay High Court had concluded that it cannot be done in the name of the another person. It should be only in the name of the assessee. And with respect to the multiple houses, the inspector's report coming out from the facts, Lordship, clearly says it's a single entrance. It doesn't say single kitchen. So there's a factual difference to that effect, Lordship. Single entrance can be created, but the kitchen is separate and there's an approval separately obtained. That is why there is a two property, two documents executed. So my humble submission, even in that context, it should be denied, Lordship. These are three aspects. Last aspect on indexation benefit, Lordship, section doesn't link it. 242A or section 49 doesn't link it. Only the interpretation given by the judicial president says it should be extended for this case also, Lordship.
Sum up, because we're running short of time. So this is a case where, for the sake of audience, there are four issues which we have tried to club with this 54 deduction. The first issue is with regard to the non-deposit of, the attempt made by the assessee to purchase a plot, which ultimately he could not construct, but ultimately the point is he has purchased a residential house within this period of 2 years. The only problem is the non-compliance of 54(2). So the courts have taken a very liberal view that 54.2 non-compliance of 54.2 is not very fatal. 54.1 complied, then it should be given the benefit of reduction. Then the second thing is about indexation. See, the indexation is what actually? It's nothing but the value of money which has been put on a property. That is ultimately indexation. So there is no point in the department trying to say that we'll give you only from 2006. 2006, nothing happened. Everything happened in 1980, and the parents settled the property. So you have to give the indexation, inflation benefit only from that date. So that, anyway, the third point is that purchase in the name of the wife. Here it's very important that you must establish as a fact that the funds for purchase of the property went from the assessee's account. If you don't establish that fact, then the decision can be different. So this is something which factually you need to establish. And then the other point is with regard to whether it's a 2 flat or 1 flat. Again here, the law is very simple. Even though on document it is 2 different flats, if it is meant to be used as 1 flat and it has been actually used as 1 flat, then it has to be regarded only as 1 property, not 2 properties. But here again, what is important to note is that you have to lay evidence. See, this is where the law doesn't help you, only evidence will help you. So it's very important, you have to have a discussion with the client, collect all these documents and establish as a fact that there are no 2 flats, it's only 1 flat being enjoyed as a single unit. So these are all the principles which this particular case highlights, and it's very good effort taken on the part of the department to find out the division benches. See, this is where, I was also taken by surprise. I didn't know that there was a division bench. But fortunately, the division bench has not overruled the single judge. They have said it's infructuous and therefore they kept quiet. So this is the kind of surprise which you will have to be prepared when the real case comes before the tribunal. Thank you. It has a persuasive value. I mean, at least there is a turbulence in your mind whether you should follow the earlier judgment. Why not? The petition is also, see, the jurisdiction doesn't matter. The High Court only matters. Whether they do it in writ jurisdiction or in a reference under the income tax law or 260A, doesn't matter. I mean, that is my feeling. You may have a different feeling. I think you use extensively writ jurisdiction. You have any specific reason, any grievance?
Case 2, Akila Kumaresan, CATV Muthu Abhirami for the assessee and DR CAY Sridhar.
I'll explain the facts in very briefly. The assessee had sold the property and had received consideration in cash to the tune of 75 lakhs. Lordship notes that this 75 lakhs has been recorded in the registered sale deed. It is very well appearing in the registered document, a statutory document, my lords. And it is not an advance. It is received only at the time of receipt of final sale consideration when the document is executed, sale deed. That's the crucial aspect in this case, my lord. And this assessee is a very compliant assessee, my lord. He had gone ahead and he had filed his return of income also, declaring 4 lakhs income under 139(1). Subsequently, the case was taken up for scrutiny, and in the scrutiny, the returned income was accepted. After accepting the returned income, there is one paragraph that is emanating in the assessment order, which simply says that
recording in progress.
It simply says that penalty of 75 lakhs is being imposed, penalty amount exceeds 20,000, prior approval of the range head has been obtained before passing the order. That is all, my lord. Lordship sees in para number 4 of the assessment order. This is the only finding given, and the returned income of the assessee with respect to the assessment is accepted. 4 lakhs, whatever I have declared, that is being accepted by the assessing officer, my lord. Now what happens is, subsequently, on the day of passing the order, and yes, my lord, before one another aspect, this assessment order is being passed by the National Faceless Assessment Unit. NFAC had passed this assessment order, and simultaneously NFAC is also issuing notice under 271D on the same day, 28/12/2022. This is the date on which the assessment order is passed, as your lordship sees from the paper book. Subsequently, other notices were also issued by NFAC on 17/1/23, 7/3/23. In all these show cause notices has been issued by NFAC, my lord. This is another fact that I would like to bring to your lordship's attention. And the final assessment order under 271D was also passed by the NFAC on 15/5/2023, my lords. These are the facts. Now, I have made 4 propositions to be precisely, my lords. My first proposition is that a penalty under 271D could be passed only by the Joint Commissioner. This is a case where NFAC has passed the penalty order, therefore the NFAC does not have jurisdiction, and by that logic, this penalty order has to be quashed. This is my first proposition, my lord. Because lack of jurisdiction vitiates the entire matter, therefore he has no jurisdiction to pass the order, and whatever amendment on penalty that came up much later, and in 2023, it is a JCIT who has the authority to pass the order. Therefore, penalty order passed by NFAC under 271D is bad in law. Show cause is also issued by the assessing officer. Penalty order is also passed by the NFAC, my lord. There is not a single show cause notice issued by the JCIT or even the additional commissioner, because the act says JCIT includes additional commissioner. Neither the additional commissioner nor the JCIT had ventured to issue the show cause notice nor pass the order. This is my prima facie first ground on jurisdiction, my lords. Lordship permits, I will go to the other grounds, my lords. Secondly, my lords, Lordship is aware, Supreme Court in Jayalakshmi Rice Mills has clearly stated that satisfaction must emanate in the assessment order before passing the penalty under 271D. It is the assessment order. In the first place, a satisfaction has to be recorded by the AO. Now, department may say that there is a paragraph stating that in para number 4, penalty of 75 lakhs is being imposed. It exceeds 20,000. Prior approval of the range that has been obtained before passing the order. Now, this, in my humble submission, my lords, cannot constitute as satisfaction. Number 1, it does not specify penalty under which section. Number 1. Number 2, merely because range head's permission has been obtained to pass the present order, that is assessment order, cannot automatically, lordship. By the NFAC, my lord. Yes, my lord. In the, it says that because 2012-2023, my lords, which is the order of penalty, my lord. So, NFAC's assessment center had merely recorded that 75 lakhs is being imposed, penalty amount exceeds 20,000, prior approval of the range that has been obtained before passing the order. I stand corrected, my lord, because penalty order being, just because there is a finding in the penalty order that the range head had given permission, it doesn't mean that the satisfaction has been obtained in the assessment order, because satisfaction should emanate at the assessment level. In the assessment order, there should be a specific finding that 269 SS has been violated. I am satisfied that penalty under this particular section has to be imposed, and then he has to forward the proposal to the range head or the joint commissioner, as the case may be. Thereafter, the procedure is that the JCIT would issue a show cause notice, finally culminating into a penalty order under 271D. in the penalty order stating that range had already been appraised of and penalty is now being imposed can never mean that satisfaction is obtained at the stage of assessment itself. This is very clearly law of the land as laid down by the Supreme Court in Jayalakshmi Rice Mills. Subsequently, even the Gujarat High Court's case had travelled to Supreme Court, Parivar Television Private Limited, even same fact, my lord. Of course, I would also explain the facts in Jayalakshmi Rice Mills. In Jayalakshmi Rice Mills, initially assessment order was passed. 271E penalty for 271E was initiated in the assessment order. Subsequently, the assessment order was travelling to the Commissioner Appeals and there the order was set aside, and in the set aside assessment order, there was no satisfaction for 271E, while there was a satisfaction under 271(1)(c). Therefore, the Supreme Court, when the matter travelled there, clearly held that satisfaction must be there in the assessment order for the assessing officer to levy penalty under 271E. 271E and D, your lordship, is ever pari materia. Therefore, I place reliance on Jayalakshmi Rice Mills and subsequent judgment of the Gujarat High Court travelling to Supreme Court in Parivar Television also, wherein this facts was clearly held. So, to conclude my first proposition, unless and until, the second proposition to be precise, my lord, unless and until a satisfaction is being recorded in the assessment order for levy of penalty under 269 SS, levy of penalty under 271D is bad in law. This is my second proposition, my lord. Thirdly, my lords, reasonable cause. Thanks. Thirdly, my third proposition is on reasonable cause, my lord. Now, the assessee had to take cash because the assessee was afraid that the check may be dishonored. Therefore, on that particular day when the sale deed was going through, he immediately took cash and immediately the property was conveyed. Therefore, the apprehension in the mind of a common man that the buyer could get the sale deed registered and then run away is possible. Therefore, reasonable cause should also be given, that prudence and reasonable cause must also be given, and therefore on that score also the penalty order passed is bad in law, my lords. There are a couple of judgments, Agarwal Construction Company and Vijapurapu Sudha Rao. Both these judgments speak about reasonable cause, my lord. I placed it in the case law book. I'll mark it and present it, my lords. And my fourth proposition now is that, my lords, lordship sees 269 SS. SS, my lords, lordship sees specified sum in the explanation part. Specified sum means any sum of money receivable, whether as advance or otherwise, in relation to transfer of an immovable property, whether or not the transfer takes place. Now, your lordship sees that it talks about money receivable, advance. All these are in the nature of advance. And that's why in my opening remarks, I submitted that this is a case where the entire 75 lakhs was received at the time of execution of sale deed. It is not as if a part of money was received as advance and then subsequently some more money was received at the time of at execution of sale deed. That is not the case here. So the entire sum was received only at the time of execution of sale deed. And this explanation is very clear that receivable and advance are all different from the money received at the time of execution. No doubt, it could be relating to immovable property, but such immovable property should be linked with an advance and not at the time of execution of sale deed. Therefore, on that score also, the penalty levied under 271D is bad in law, my lord. To sum up, my lord, my fourth proposition, number one, order passed by the National Faceless Assessment Center is bad in law because it ought to have been passed only by the JCIT. Number two, an order of penalty wherein no satisfaction was being recorded at the assessment level cannot be sustained in the light of Jayalakshmi Rice Mills and Parivar Television. Number three, reasonable cause of apprehension of not receiving the money. And fourthly, my lords, the section itself is inapplicable in the present case as 269 SS can be invoked in respect of an immovable property only if the money is received in advance, not at the time of execution of sale deed. On these four scores, the penalty order cannot be sustained is my humble submission, my lord. Let the order be quashed, my lord. Obliged, deeply obliged.
there are cases, my friend was talking, and there are cases where it is not in the ground, and beyond the ground she has gone. But anyway, our honors are allowing her to file additional grounds that may be considered. And here, and let me answer from, say, from the reasonable, she has said, there is a third ground, error in not appreciating that the appellant has had reasonable cause as per the provisions of section 273B of the Act. Here she says there is fearing of dishonoring of check, I don't want to take a risk, whereas the same assessee is prepared to take the risk of carrying such a huge money, not even with an agreement entered in advance and going to the sub-registrar office. So the risk phenomena, what my learned friend is telling, is not getting into my mind, Your Honor. That is one part. And other things, no, just because there's a reasonable cause is not there. You cannot say that when somebody can carry 75 lakhs and go to sub-registrar office, fearing nothing, but will fear for bouncing of check. Bouncing of check, maximum what will happen, Your Honor, the sale will become infructuous. So they are not going to lose. When such a scenario, the risking of check bouncing is not a reasonable cause, number one. Number two, and as far as the satisfaction is concerned, the paragraph number 4, it's of the assessment order, which says, accordingly, penalty of rupees 75 lakhs is being imposed as the penalty amount exceeds 20,000. No, it says, accordingly, being imposed. It is not the original. No, it says, Your Honor, I will read that. Upon the perusal of the assessment order dated 28/12/2003, it can be inferred the assessment unit, National Faith Assessment Center, had merely recorded in paragraph number 4. So, meaning it is about the assessment order, Your Honor. That is my.
Also, living of penalty
Your Honor, by mere reading of this, what is coming out is, upon perusal of the assessment order dated 28/12/2023, it can be inferred that the assessment unit, National Facilities Assessment Center, had merely recorded in paragraph number 4 as follows. Meaning they have recorded the assessment order. That is my understanding, Your Honor.
But if you read it, if you read the wordings, that is actually penalty is imposed. So that is the penalty order. Accordingly, penalty.
But it is not clearly coming out from the.
But it is the penalty order where the penalty has been imposed. The assessment order doesn't have any reference to the initiation of penalty under 271.
But the simple reading throws like that only, Your Honor. And again, it's quantum versus compliance, Your Honor. Quantum, okay, their capital gain has been accepted. It doesn't mean the compliance there. Compliance, if there is any fault in compliance, that can be seen even later stages, like 271B can be taken up any time. Similarly, it's only a compliance stage, so that can be looked into at any point of time, Your Honor. Yeah, yes. Like 271B or something, because I want to distinguish between the compliance and the quantum. Quantum, my learned friend is right, but as far as the compliance is concerned, they missed out, Your Honor. So as far as the reasonable cause is concerned, I said why there is no reasonable cause, and a recording of satisfaction, even if it is not recorded also, like being a compliance.
Not linked with the assessment, and therefore
Yes.
it can be independently initiated.
Yeah, being a compliance, not a quantum, that can be independently given. And as far as the genuineness and it is all paid across the counter, there is no such finding. See, there are cases where even the sub-registrar is also party to that, and he said, yes, I have received. If such a thing has not come out from their submission, Your Honor. If that is coming out, probably Your Honor can take a. I strongly support CIT appeals order, Your Honor.
Lordship permits me to make my rejoinder minutes.
We'll just sum up fast.
Just a minute of my
sure.
this thing, Lord. First of all, reasonable cost sale deed, my lords. My learned friends, my learned senior says that nothing is going to happen, the sale deed become infructuous. There are very many cases, my lords, where after the sale deed has been executed and the money has not been received, department has come behind us asking for capital gains. We don't know all that sale deed has been registered, pay the capital gain. So there the reasonable apprehension has to be given some weightage, my lords. Secondly, even assuming that the satisfaction has been recorded in the assessment order, still it would not be applicable, mainly because it doesn't say 269 SS or range at nothing, my lords. So on that score also, that cannot be accepted. Even assuming that satisfaction is recorded in the assessment order, that's not a proper satisfaction. Secondly, my lords, satisfaction not required when it comes to a non-income based penalty versus an income based penalty. Suppose if it's an order under 143.1, assuming for 271(c), if it's an order under 143.1, obviously there is no necessity for a satisfaction. But if it's an order under 143.3, there is a satisfaction requirement, as Supreme Court has held in very many cases. On applying the same thing, if the 269 SS has been independently taken up without the assessment order being passed, suppose there is some information that a person has transacted in cash, they come behind me under 269 SS, agreed, satisfaction point is not required. But moment there is an assessment order and after recording that no income is payable, no addition is being made, then satisfaction assumes importance, my lord. Only in that context, satisfaction point has to be seen. And lastly, my lord, the provision on 269 SS has been introduced only to curb the black money. The moment it is registered and the moment I declare everything, the objective of the provision must also be seen, my lords. In this context, these are my submissions, my lord. The appeal may be allowed. Obliged, deeply obliged.
The short point in this appeal is that when the penalties are levied by the National Faceless Scheme, most of the penalties were levied by the assessing officers, excepting certain penalties like 271C, D, 271C, D, E and DA. So these are the penalties which required the JC's approval. So in this case, the amendment in the Act that the assessing officers in the faceless scheme can also levy the penalty is from 1/4/2025. So that is a crucial point where the entire foundation of this order would fail. Further, the way the case is presented, the reasonable cost should be presented at the last and not in between, because when you have the legal issues of the order not passed by the concerned authority, or the satisfaction not recorded, or whether it is an advance which is liable to the penalty, or whether it is the final consideration, all those have to be taken up. And if you fail in all these, only the reasonable cost should come up. So the order of presenting should also be looked into. That is my practice notes. No offense meant.
Third case, Mr. Vishal Radhakrishnan, CA M. Vishwanathan for the assessee and CA Anand Babunath DR.
So the appellant is an individual and he is a tax resident. This is pertaining to assessment year 1819. She was employed in Australia from 2017 to 2019. So as per global income, whatever salary earned in Australia, she is supposed to offer income in file his return and offer tax in India. So the foreign income was offered and she is also entitled to claim foreign tax credit. So the return, when she files the original return, the assessee has not filed the form 16 because there is one requirement called form 16 which has to be filed as per rule 128 subsection 9. Subsequently, she has claimed foreign tax credit only at the time of filing the revised return for amounting to 4.73 lakhs. At that time also, the assessee has not filed the form 67. Subsequently, on realizing the same, she has filed form 67 in the year 2020, just before completion of assessment. So the CPC has completed the assessment by not allowing the foreign tax credit. Against the said CPC order, the assessee filed a rectification petition before AO. The AO has also disallowed the same. Against that, the assessee has filed an appeal before CAT. The CAT has made a passing observation that form 67 is mandatory, ought to have been filed before filing the return. But even though it's a procedural requirement, the assessee has not filed the form 67 before filing the revised return. Therefore, the CIT has disallowed the same. It is again the said disallowance, the assessee prefers an appeal. I like to take 7 grounds in this. So the ground number 1 is the CIT appeal is heard in disallowing foreign tax credit, though section 90 and article 25 of DTA grants a substantive right to credit of foreign tax paid, because there is no provision in the act or treaty mandate that FTC should be denied by not filing form 67. I will just read that operative portion of section 90. Section 90 subsection 2 says, where the central government has entered into an agreement with the government of any country outside India or specified territory outside India, as the case may be, under subsection 1, for granting relief of tax, as the case may be, the avoidance of double taxation agreement, then the relation to the assessee to which the agreement applies. The provisions of this act shall apply to the extent they are more beneficial to the assessee, because the word used is shall, because it is a beneficial provision given to the assessee. Also, Article 24 of the DTA, which mandates the assessee to claim credit whatever tax paid in Australia, India and Australia, clause 24(4)(a). Clause 24(4)(a). And also, Rule 128 subsection 9 says, the statement in Form 67 referred in so and so and the certificate in so and so has to be filed before the time specified under subsection 1, that is original return, or subsection 4, belated return of section 139. Nowhere the rule says by not filing form 67 the benefit cannot be denied, because the rule is silent. The rule is passed only by the CBDT for administrative convenience. It cannot override the treaty or the act. It is only a procedural matter. Also, for delay in form 67, accordingly is a curable defect, and this also disallowance under 143(1) cannot be made, because prima facie adjustment cannot be taken by not filing form 67. This issue has to be taken only at the time of assembly, because even though CPC has got no right to deny foreign tax credit, it is a debatable issue, and AO has correctly held that is a debatable issue, and it has filed an appeal before rectification petition, and before completion assessment form 67 has been filed. In spite of that, the AO has not considered the same, because there are some judicial precedents also in case of Mangalore Chemicals, even though it is related to sales tax. I'll just read that relevant paragraph. This is mainly Mangalore Deputy Commissioner of Income Tax, Mangalore Chemicals Limited versus Deputy Commissioner of Income Tax, 1992 AR 152. This is interpreting provisions. In para 11, I'll just read that operative portion. The mere fact that it is a statutory does not matter one way or the other. There are conditions and conditions. Some may be substantive, mandatory and based on consideration of the policy, and some others may merely belong to area of procedure. It will be erroneous to attach equal importance to the non-observance of all the conditions irrespective of the purpose which they intend to serve. Because this is the observation made by the Supreme Court. So it's a curable defect. Just because by not filing form 67, the disallowance cannot be made. That is my humble summation.
May Your Honor? My learned friend said that it's mere procedure and it's not mandatory, and he referred to Rule 128, Sub-Rule 8 and Sub-Rule 9, and also read Section 90, Subsection 2. The fact is, the Act has laid down a parameter which is required to be complied with. The Form 67 is necessarily to be submitted before the authorities for them to verify and allow the credit. Merely withholding this and then filing a return of income is primarily nothing but you don't provide the data and you allow asking the Department of Revenue to grant the benefit under the law. First of all, the question is foreign tax credit can be allowed subject to the condition that Form 67 is enclosed with tax challan certified copies, and the relevant income source and how it has been generated overseas, for which it requires to be reported when you are resident for that particular year. If you are a non-resident, it is not applicable. It doesn't go carry also. But in our case, in the assessee's case, appellant filed the return, then it revises the return, and also when the above, 143(1) CPC processing is pending, it suo moto files one more copy saying that Form 67 is now I forgot to file, I just file it. It's nothing but it takes its own course, and the law laid down is not adhered and it is taken for granted. So in the process, I just would like to insist that the law laid down and the rules prescribed are subordinate to each other, and it has to be followed strictly. Though it is not mandatory, but it has to be followed. Therefore, the revenue will stand to lose if it permits all this lax structure approach to the department in filing the papers. Otherwise, there are interpretation, as my learned friend also referred, that interpretation has to be done where there is no penal proceedings or penal clauses are prevailing in the relevant DTAA as well as the provisions. But for a strict application, when a benefit is given, it should be strictly interpreted. It cannot be interpreted in a lucid way. So my argument is that it should be denied. Basically, the claim made by the appellant is only after it realizes its mistake on a stage by stage. And after 154 is a debatable, where debatable issues cannot be taken up. Even that particular order is raised before CIT appeals, and CIT appeal rightly decided that it cannot be brought before it. And I request you to kindly dismiss the appeal yours.
Only one submission, sir. The Income Tax Act, there are many sections which deny deductions or exemption in case the audit report is not filed well within the time, like 80 IAC, 10 A subsection 5(4). Similar provision is not available under 128 subsection 8, because the rule says the form has to be filed, but nowhere the rule says only the form has to be filed. Nowhere the section says if the form is not filed, the disallowance will be made. Because there are some specific section under 80 IA 7, 10 A subsection 5, where the return is not filed, you will lose the exemption or deduction. Similar condition is not available with regard to Form 67.
See, this is a very classic case where the provisions are very clear, and any practitioner would be really puzzled as to how to get over this problem of not filing the required form within the time due date specified in the section. See, the lawyer who has argued this case has gone to the very basis of the foreign tax credit. He has gone to section 90 of the Income Tax Act, and he has made out a case that the Income Tax Act, the DTA will prevail over the Income Tax Act. So once that point is accepted, and this is an accepted position, section 90 subsection 2 is very clear on this point. The DTA between India and Australia clearly permits giving of credit, rather mandates giving of credit. So now when the rules are made under the Income Tax Act, the rules cannot override the statute. There is a fundamental rule, fundamental principle in law is that the rules are subordinate, it cannot override the provisions of the Act. Here, though the DTA overrides the Act, therefore whatever is prescribed in the rules or cannot provide. That is the first ground. And the second point is that the use of the word shall, whenever the word shall is used, there is generally a presumption that it is mandatory. What is very important to, even in such scenario, what you should do is, you should find out what is the purpose of the rule, and though the word shall is used, it is to be construed as may. And there are several decisions on this point, when you can construe the expression shall as may. So mandatory or directory. After all, what is the purpose? In this, the DR has made out a very valid point that if the required form is not at all filed, then what do we do? Then probably he can make out a case. But in this case, he has filed a revised return along with the required form. So now that the statutory compliance has been made, there will be no useful purpose in doing the disallowance. So this is really a very classic case where you have to accept, you have to appreciate the argument of the counsel based on section 90. That is a very, very key factor which all of you should notice. Whenever you are concerned with a DTA matter, it should come to your mind that the DTA provisions will prevail over the Act to the extent it is beneficial to the assessee. So this is the highlight of this case.
Case number 4, Kundan Jewellers, CA Arun Raj for assessee and CA Yashwant Kumar DR.
Lordship, I beg to appear for the assessee in this case. Lordship, to give a brief background of this case, in this case, there's an addition made with respect to cash deposits made during the demonetization period. The assessing officer has invoked section 68 and treated the cash deposits made during the demonetization period in SBNs as unexplained credit. Lordship, just to give a brief background of the assessee is into the business of jewellery. And he has been there, the partnership firm has been there in the last decade and regularly filing the returns of income, regularly maintaining the stock books and getting its books audited. The only contention of the assessing officer is that there is an abnormal sale during the demonetization period and there is a cash deposit, abnormal cash deposit made out of those, according to the assessee, it's out of the cash sales. According to the assessing officer, it is unexplained and it is not linked to those sales. And he has treated it as unexplained credit under section 68. My line of arguments, the first submission is that if your honors go through the assessment order, the assessing officer has not invoked his powers under section 145. My books are not rejected. I have placed on record the cash book, stock book, the sales register, purchase register. Nothing has been tampered with or questioned by the assessing officer. The only aspect which the assessing officer questions is the deposits which I made during the demonetization period to the tune of 2.7 crores. So my humble submission, my books are audited under the Income Tax Act. There's a tax audit report filed within the portal. And having not disputed any other aspect of the books of accounts, especially by not invoking 145, he has accepted the opening stock, he has accepted the purchases, he has also accepted the closing stock. Now he cannot tamper with a particular deposit and say that that is unexplained. That is a preliminary argument which I'd like to make. The reason being, Lordship, since I'm maintaining the stock book register, the assessing officer is also aware that as per my stock register, as on 8/11, there was stock available with me. The gold was available in the stock register and there is a reduction in the extent of stock which is being sold in the subsequent days. So my humble submission, having accepted all other aspects, choosing only the demonetization deposit is only based on a suspicion and doesn't back by any other valid evidence, Lordship. And one more finding which the AO gives is that I did not give the details of the buyers. Lordship, I am into the business of B2C. I do retail sales. The only detail which I am able to collect from the customers is the name and address, whatever they give. Instead of doing the business, I can't keep doing the due diligence and verify whether the name given and the address given is right or not. And whatever the details which I've collected from the customers is available in my sales invoice. So the pointed issue is that, Lordship, no act thrust upon me to do a due diligence and identify the identity of the persons unless it is above the threshold limits. Lordship, in this case, all sales are within the threshold limit of 2 lakh rupees. There is no dispute on that. Even the 50,000 threshold limit for the other purposes under the other enactments came very recently in the year 2024. At that point in time, there was no enactment which mandated me to collect or do any due diligence, Lordship. So I don't have even an authority to ask for the identity from the customers. I have to go with what details which they give. So even on that ground, Lordship, I have complied with all provisions. There cannot be any suspicion for treating it as unexplained credit. One point which I would like to highlight, Lordship, the apprehension of the assessing officer is that I had received SBNs after 8/11. Lordship, this is one issue which I would like to address, whether it is an offence or not for receiving money after 8/11. Lordship, I like to just highlight the Cessation Act, Lordship. I'll just screen share just a minute. Lordship, considering the time, I'm just running a little fast. If in case if it's too fast, Lordship may let me know. Pointed issue which I'm trying to address here. There is a Cessation of Liabilities Act 2017 which has been introduced, Lordship. Lordship, this act, if your honors notice there, it was enacted on 27th February 2017. Lordship, this, what happened, Lordship, on 8/11/2016, on the night when demonetization was announced, there was a notification issued, Lordship, stating that the legal tenders shall cease, the currency shall cease to be a legal tender. Lordship, all it stated was, it shall cease to be a legal tender. There was no offence or anything in transacting with that as per that notification, Lordship. Subsequently, there was an ordinance passed in the name of Cessation of Liability and it became an act on 27th February 2017. Lordship, I refer to that act, section 2. The appointed date says, appointed day means 31st December 2016, Lordship. This was the appointed day. And if your honors read section 5, Lordship, this is the first time there is an offence being brought under an act to transact with SBNs. Section 5 reads, Lordship, prohibition on holding, transferring or receiving specified banknotes. On and from the appointed date, Lordship may note this, on and from the appointed date, which is 31st December 2016, no person shall knowingly or voluntarily hold, transfer or receive any SBNs. Lordship, my humble submission, Cessation of Act says the offence or the prohibition comes only from 31st December 2016 and not from 8/11/2016. From 8/11/2016, even though it ceases to be legal tender, and even I have, even assuming for a moment I have received money in SBNs, it should be considered only as a business transaction, especially for Income Tax Act, and there cannot be any other view taken by the assessing officer just because I have received SBNs, Lordship. So even on this ground, I would like to submit the action of the assessing officer in treating it as a unexplained credit falls to ground. The next aspect which I like to highlight is that, Lordship, rate of tax being applied at the rate of 60%. This is an alternate plea, Lordship. Even assuming for a moment that your Lordship are rejecting my plea and concluding that it's an unexplained credit, Lordship, the rate of 60% has been applied. Lordship, this rate of 60% was again introduced after the demonetization. This was brought in through an ordinance initially and then became an act through TOLA. And this ordinance, Lordship, was brought out from press release. Lordship, this press release is dated 1st December 2016. I'm sorry, the full screen is not getting displayed. So it was dated 1st December 2016. For the first time, the enhanced rate of tax has been introduced. Now, Lordship, and this became an act only after that, that is sometime in 15th December, when it got enacted through TOLA. So my humble submission is that, Lordship, being an act which has been introduced in 15th December, can it cover transactions which happened before that? Because as a taxpayer, I should be entitled to plan my affairs. I cannot be brought in surprise and say, last 6 months transaction, I'll tax it at 60%. Or last 1 year transaction will be taxed at 60%. So as a taxpayer, I should be entitled to plan my affairs. Lordship, in this context, I would also like to refer section 294, Lordship. At 294 says, on the first day of that particular year, whatever the tax affairs are there, subject to the pending bills also, whichever is beneficial to the SC can be applied. And hence, in this context, 30% is the applicable rate as on that particular day in which I transacted. So 30% should be applied and not the new rate, Lordship. To gain strength on this argument, Lordship, there is also a recent decision of the Madras High Court. Before that, Lordship, there is a Supreme Court decision earlier rendered. In the case of Karimuttuviri Tea Estate, 60 ITR 262, Lordship. There, Lordship, in the context of State Tax Act, in the context of State Tax Act, it was concluded that the tax liability can be thrusted upon only prospectively and not retrospectively, Lordship. Recently, the Madras High Court in the case of Smile Microfinance, Lordship, by the order dated 19th November 2024, had categorically stated that this amendment will apply only from 1/4/2017. Transactions commenced after 1/4/2017 and hence would not apply for assessment year 17-18, however will apply for assessment year 18-19. In this argument, Lordship, if 30% is applied to the facts of my case, the alternate plea, assuming for a change I agree with my friend that it's unexplained credit, let them tax it as unexplained credit at 30%. But my only request is let them reduce it from my sales, Lordship. According to them, it's not their sales, it's not my sales. So if they reduce it from the sales, let them tax it at 30%, it will be the net nil effect, Lordship. It will be an academic exercise which has to be carried out. So my humble submission, if this 30% alone is granted, the other issues would become academic, Lordship. On both the grounds, I plead for deleting the addition as well, granting at 30%.
Appearing for the respondent, Your Honours. Your Honours, the first contention which was taken up by my learned friend is that the assessing officer has not rejected my books of accounts. Your Honours, to invoke section 67, it is not necessary that books of accounts has to be rejected. If in case, if the assessing officer comes across a credit transaction in the books of accounts, in that case, he can invoke section 68. The assessing officer in this case, during the course of assessment, has come to know that the assessee has done some sale transaction, say on 8th, 9th, 10th, whatever the date it is. In the invoices, the assessee has just stated cash sales. A few minutes back, my learned friend said that he is bound to collect two details. One is the name of the assessee and the address of the assessee. But the invoices which has been produced during the course of assessment, it is very clear that only the term cash sales is being used. So based on that very fact, it is very clear that the sale has not been done to any of the individuals or say any of the customers. Whatever cash which was there before the demonetization with the partnership firm was being utilized in a fashion that it will represent as if a sale has been done and then the same sale proceeds has been deposited in the bank account, Your Honours. The other thing was what my learned friend was trying to say is that my stock register has not been disturbed by the assessing officer. Your Honours, it is not disputed that the assessing officer has in the order has stated that he has looked into stock register. But just referring to stock register does not mean that the assessing officer had a look into it in detail and then he has given a confirmation that yes, the stock which was there in the books is been properly sold and then is properly been accounted as sales in the books of the assessee. So that cannot be a plea that whatever books is being maintained by me is proper. So and the assessing officer has also not disputed that fact. So that plea will not stand, Your Honours. Then the other thing which with my learned friend was relying on is that he is entitled to do transactions till 31st of January in SBNs. But what I would like to just bring to notice is that, sir, there was an exemption category circular which was issued by the central government, wherein the specification in connection with jewelry business is not been brought to the notice of the individuals, wherein if any sale transaction done in connection with jewelry for the period so and so can be classified under exemption category. The fact that the central government was very clear that such transactions should not be brought under exemption category, the sale transactions were not, the jewelry sales were not brought under the exemption category. The circular is filed in paper book which was filed before, Your Honours. Your Honours, my learned friend even said that the sale, if it is being reduced, will not have any impact. The primary contention is that the sale as such, the profit or the GP or say on that sale is what is being accounted as income in this case. It is not the whole of the sale which is being paid on that amount. The taxes is not being paid by the assessee. So the contention that if the sale, if the contention is that the sale amount is being reduced from my the cash portion of sale is being reduced from my sale account, it will not have an impact, is not is not feasible. But if it is being separately considered, then on that amount 30% is what is to be charged. If that plea is taken, then whatever GP on that is being calculated, that may be reduced, then the difference amount may be taken up as at 30% along with applicable surcharge and cess, Your Honours. Your Honour, since the invoices which were produced during the course of assessment did not have any reference to any of the individuals, it itself clearly states that the transactions which were done are bogus transactions. Just to bring in the money, it has been accounted by the assessee firm. Then on the last point, 115 BBE, it has been brought in effect with from 1/4/2017. So I feel it should be applicable from 17/18, Your Honours.
If your Lordship permit 30 seconds, I would like to give a rebuttal, Lordship. The Lordship's permission. Lordship, there are 3 rebuttals, short rebuttals, which I would like to give. First is the stock register, which has been stated by my learned friend. Lordship, the closing stock has not been disputed. My P&L has been arrived at by closing stock, and it is a fact that I am not in the business of petroleum where my stock will get evaporated. I am in the business of gold, Lordship. As on 8/11, after 8/11, there is a reduction in gold. Where did that gold go? The assessing officer accepts that there is a reduction in gold because he has accepted the closing stock value. Now to say that I have not sold it, but on the other side my gold has vanished, is something will distort my financials, Lordship. So on that ground I submit it's a sales transaction which cannot be disputed. The second aspect, the exception on the circular. Lordship, I am not claiming any exemption under the circular. All I am saying is I have not committed any offence under the Act. This is one aspect. Even assuming but not conceding for a moment that I have committed an offence under the RBI or other Act, will it have an impact under the Income Tax Act? Lordship, according to the Income Tax Act, what has to be seen is the nature of transaction and the identity from the persons from whom I received it. Both I have established through the sale bills as well the gold being reduced. The third aspect, GP to be reduced. Lordship, till that extent my friend was saying I did not report any sales. It's an unaccounted income. Now I was saying it is an unaccounted income and saying GP should be reduced. It's like going hot and cold on the same point, Lordship. My humble submission, if they don't want to treat it as sale, let them treat it as unexplained credit, but reduce it from sale. GP should not be reduced because a purchase according to the department pertains to the accounted sales purchases. It is not towards the disputed competence purchases. So these are my short rebuttal.
Just some practice notes on this matter. First, you should have also brought to the attention that whether these sales have been accepted in your VAT returns, because in that period you had VAT, and if it is accepted in the VAT returns, that would be an evidence which will strengthen your case, because up to 2017 you had the state VAT on this, and also you had central excise also on some of the gold coins and other items. So that is one aspect. Secondly, there is a fallacy if you ask the sales to be reduced and taxed as other sources accepting the department's contention, because by reducing the sales, there may be a negative figure in your GP, but it cannot be set off against the addition under 68. That loss cannot be set off. So there is a fallacy in that argument. And third, if it is the income that is already offered for tax under sales, it cannot be carved out for an addition under 68, because 68 is relating to capital transactions either as loan or as a share capital or loan, where mainly you don't offer it as income. If it is already offered as income, you don't have to make an addition under 68. So these are just practice notes. I would not dwell on the validity of whether you can accept cash during demonetization time or not. You can call the next case.
Case number 5 for Chennai Plastics and Fiber Products Private Limited. CA Y Sridhar sir for assessee, Muthu Abhirami for DR.
Engage in business of government exports, and they have claimed it is with reference to 80 HSC. Whether from my profit and loss account first I can claim 80 HSC and take my carry forward loss get adjusted, or I have to arrive the gross total income I have to bring in my carry forward loss first, then apply 80 HSC. See what the assessee has done originally, he has filed a return without claiming 80 HSC, because even if we have give effect to the carry forward losses, still it was negative. So he has filed return. During the course of hearing, he has given a revised computation claiming 80 HSC first on the income from business or profession of that year. Then subsequently he has adjusted whatever left, he has adjusted the carry forward loss. That is the thing, and assessment has been passed as per the assessee's wish, in the sense whatever he has filed subsequently during the course of hearing, that has been accepted and passed. So, subsequently, it has been 263 has been invoked by the commissioner, calling this as erroneous and prejudicial to the revenue. Here, first of all, what is erroneous? Because according to them, they have not followed particular case law. That is, how the assessing officer has given relief, he has gone by a case law, CIT versus Kojiri Tobacco, 1999, Your Honor, very important, 238 ITR 970. And CIT quoting Kothagiri Industrial Cooperative Tea Factory, 224, 1997, Your Honor, very important. That is 1999, it is 1997. 224 ITR 604, laying down that 80 A2. Here what he is telling, you cannot, you have to give effect to the 80 HSC after adjusting the carry forward loss. See, honestly speaking, this Kothagiri Industrial Cooperative Tea Factory case is nothing to do with 80 HSC. It is a case of a ATP. ATP speaks about what is gross total income. The way it starts, Your Honors, where in the case of an assessee, being a cooperative society, the gross total income includes any income, gross total income includes any income referred to subsection 2. Such clause is not there in 80 HSC. ATP case cannot be used against mine. Mine is an 80 HSC case, Your Honors. And so that is the case, there is no erroneous, because my assessee has, assessing officer has followed what is the case existence on that date. Subsequently, there may be a Supreme Court decision against me. You cannot call him erroneous because that fact is not known to him. That is not in the either in the books of statute or by way of a Supreme Court decision or a jurisdictional high court decision. And they have taken a decision. In 263 they said the Kojini tobacco is from AP Whereas you have to go by the jurisdictional high court decision, Kotagiri Industrial Cooperative. The Kotagiri Industrial Cooperative, had it been in 80 HHC field, then that is fine, Your Honors, whereas it is in the 80P, nothing to do with my case. And so, this is not, on the face of it, it is not erroneous. He has followed the correct case law, so it is not erroneous. From the second perspective, whether it is prejudicial to the revenue, see here, Your Honor, what has happened after all, my carry forward loss. If I am not adjusting this year, assume for a moment you are not allowing me to adjust this year, I am going to adjust in the next year. What is the real loss? Anyway, that loss is an asset. Loss is an asset as per our balance sheet also, as well as for my income tax also, because I can claim against subsequent years, Your Honor. In such a scenario, there is no prejudice to the revenue, Your Honor. It is not, the revenue has not lost anything, because after all, if I am not allowed to claim this year, I am going to claim in the next year. And the top of it, assessing officer, it is not written filed and he has taken decision. During the course of hearing, I have given. So he has, gone through everything. He has, I have taken all his bullets. Now his bullet fails. Now you are allowing him to use the butts. That cannot be allowed, Your Honor. That is the other part as far as this. The two conditions are not satisfied. One, he is not erroneous. Another thing is there is no, it is not prejudicial to the interest of the revenue. On the top of it, Your Honors, I am taxed under 80J, 115JA. So 115JA on book profit has been taxed. Having taxed me on 115JA, and again you say there's a prejudice cost to the revenue, that is not acceptable, Your Honors. So 263 has to be cost, Your Honors. Paucity of time, I don't want to go further. If my department representative come heavily, I will be given a chance to address that.
May I please, Your Lordship, appearing for the department, respondent here in this case. Lordship, first of all, before I make my submissions on 263 validity, first of all, on one submission made by my learned senior, having accepted all the bullets, now they cannot come back, is that if it is a case of reopening, I accept. Having gone through everything and then you cannot come back on the same issue. But the very purpose of 263 is that an error committed which is prejudicial to the revenue committed by an assessing officer has to be rectified. That is the prima facie view, or that is the most important aspect why 263 is there in the statute book. I cannot go under 154. It's not a mistake apparent on record. So I need to use 263, and it's not a case, change of opinion concept would not be applicable in the case of 263, my lords. That is my prima facie argument, first of all. Secondly, my lords, my learned senior stated that Kotagiri would not be applicable. But even before going to the Kotagiri, Lordship sees the relevant sections 80A2 and 80B5, my lords. Lordship sees 80B5 first. It clearly states that gross total income means the total income computed in accordance with the provisions of this act before making any deduction under this chapter. This is 80B5, my lords. And 80A2 is that the aggregate amount of the deductions under this chapter shall not in any case exceed the gross total income of the assessee. 80 HHC along with 80A2 and 80B5 mandates that in the first place it is a loss which has to be set off, and then only a deduction under 80 HHC is possible, and not the reverse way. Assessee cannot take use of double benefit. They cannot now take the benefit of 80 HHC and then they keep the loss intact, and then after some period till the completion of 8 years period they want to make use of loss adjustment. Is not permissible. That's not the intent of the act when the benefit of 80 HHC was given to the assessee. That is my second submission, my lord. Thirdly, Kotagiri Industrial Cooperative Society is very clear. It is a law of the land, Supreme Court, and it is binding. And Gogineni, my lords, most importantly, when the matter travelled to the Supreme Court, even when the 263 order was being passed, it was reversed. And the order was passed in the assessee's appeal was, the position in favour of the assessee was overturned. Now the matter stands in favour of the revenue even in Gogineni. And Gogineni is the basis on which the assessing officer is allowed. First of all, placing reliance on Gogineni itself is bad in law because it is not the jurisdiction high court, it is not binding. In the grounds of appeal, the assessee had taken a view that they want to rely on GM Mittal's stainless steel, where jurisdiction high court is possible. They relying on a jurisdiction high court and then passing an assessment order is possible. But this is not a case of jurisdiction high court. So Gogineni is of Andhra Pradesh high court, which is not a jurisdiction high court. Therefore, placing reliance on that is not correct, first of all. Secondly, Kotagiri Supreme Court judgment already exists on the date on which the assessment order is being passed. Therefore, that should have been given credence rather than Gogineni of Andhra Pradesh High Court. Secondly. Thirdly, Gogineni is already under challenge when the assessment was taking place. And now when the 263, before 263 order was being passed, Supreme Court had reversed Gogineni and the issue is settled in favor of the revenue. And most importantly, your Lordship is very well aware, unless the Supreme Court clearly states that doctrine of prospective overruling applies, all the judgments are declaratory in nature. On the date of deduction, what is the law is what is being interpreted by the Supreme Court. Therefore, it is very clear that Gogineni will not be applicable. The position that you can deduct 80 HHC and then you can go for set off of loss is not correct. It should be set off of loss first and then 80 HHC. That is very well laid down even in Gogineni. Even assuming that the reliance on Gogineni is correct, the position is no longer good as the reliance made by the assessing officer. That is one part of it, my lords. And secondly, in their grounds of appeal, they have stated that when two possible views are there, when the assessing officer chooses one possible view, that is 263 will not be applicable. They relied on Malabar Industrial Company. Here I would like to submit that, my lords, two possible view means both the views should be correct. When the Supreme Court has already laid the law clearly that against assessee, the assessing officer cannot say that no, there is two possible views and I relied on the Andhra Pradesh High Court's judgment and based on which I passed the order is not proper, my lords. That is my next submission. And another importantly, IPCA Laboratory Limited is again a Supreme Court judgment which had cemented the position that 80 HHC has to be taken up after adjusting the losses. So there also again Supreme Court comes in favor of the revenue, holding the issue in favor of the revenue. And as I mentioned, my lord, Supreme Court judgments are only declaratory in nature. Therefore, the law as it stood at the time when in the statute book has to be seen and not at the time when the order is being passed. So we cannot take a view that it came subsequently, therefore it cannot be treated as erroneous. Is not the correct position, my lords. So based on which I strongly rely on the 263 order passed by the PCIT and according the appeal has to be dismissed, my lord. Deeply obliged.
Talking about everything, but she has thoroughly given up her, there is no prejudice cost. That is from them also. They don't have grounds on prejudice. I have paid tax on 115 JA and even the loss is not allowed this year. The loss will be there and it will be used. See, for that matter, if I not deducted TDS, for that you are making a 263. Okay, if this year I am not paying immediately after my assessment, if I paid the year of payment, I am going to claim it. That will not come under the purview of 263 because there is no permanent loss prejudice cost to the revenue. Here also there is no permanent prejudice cost to the revenue because my carry forward loss will be intact if it is not allowed to be set aside this year. So that is my submission, Your Honor. So the twin condition to be satisfied, twin condition at least to the extent of prejudice is not even supported by revenue. So 263 order to be quashed, Your Honor.
See, the important aspect of this case is exercise of powers under section 263. So there are, all of you are aware that an order can be revised under section 263. It is erroneous and prejudicial to the interest of the revenue. So here is a case where when the assessment was completed, the assessing officer, his claim was supported by a decision of a high court. It is a non-jurisdictional high court, but doesn't matter. High court decision is binding, whether it is that of jurisdictional or non-jurisdictional, so long as there is no contrary judgment of the jurisdictional high court. That is the position. So the AO has accepted the claim of the SSE and he has allowed the claim without set off of losses. Now the department says that the basis on which the AO accepted the claim of the SSE, there is a high court order, is under challenge before the Supreme Court, and therefore unless the Supreme Court has the final word in the matter, we will not. This order is erroneous. That is the stand of the department. So the point is, 263 jurisdiction is there in the Act for the purpose of protecting the interest of the revenue. So as counsels, we must understand that it's a level playing field for both the SSC as well as the department. So 263 is a area where the officers will have to protect the interest of the revenue. So if some wrong orders are passed, they have to interfere. That is the whole purpose of jurisdiction, the revision jurisdiction. Now in this case, normally in given circumstances, 263 will not be upheld. But here is a case where the matter is subject to appeal in the Supreme Court. And ultimately, what happened was the Supreme Court accepted the position of the commissioner in the order under section 263. Therefore, set-off has to be done. If there is set-off, there is no profits available on which reduction can be given under 80 HSC. That is the factual position. So, the interest of the revenue has to be protected, and as the learned Department Counsel rightly pointed out, the Supreme Court, law declared with the Supreme Court is applicable right from the beginning, unless the Supreme Court says that this decision will not operate for past transactions or for past cases. So, doctrine of prospective overruling is not been done. So, in that case, the AO's order is erroneous. Of course, it becomes erroneous only at a subsequent point of time, but still the jurisdiction under section 263 has been upheld. So it's a level playing field. What is important to understand is that the Act has provisions both to protect the interests of the SSC as well as the revenue. And here is a case where the jurisdiction has been rightly exercised by the Commissioner under 263. This is the whole summing up of the case. Thank you.
The last case for the day, Insulplast Engineering, CA Anand Babunath for Assassi and CA Vishwanathan for DR.
Yeah.
The such case, there is a group called P, which one Assassi is associated, and the section 132. There is a group P in which Assassi is associated, and such was happened on 21/6/2011, for which the notice under 153A was issued. It also transpired that BBR one group is there. There are 2 directors in 7 group companies. The Assassi holds, the P group Assassi holds 99% shareholding, whereas BBR was holding only 1% share. During such proceedings, it was found that over and above the declared sale consideration of land, some all money amount was also paid to the director for the sale of land of the group company. So during investigation, some undisclosed bank accounts of BBR were discovered, and a sworn statement was recorded, and the Assassi has stated that BBR is a business associate, wherein they hold only 1%, and they handle the affairs of the company at Chennai. On these facts, the learned AO concluded BBR merely acted as an executive on behalf of the director and was more of an employee. The wife and legal heir of BBR also stated that BBR only looked at the affairs of the group company and he did not carry on any business activity, because this is very, very important. They say we carry on only the activities of the, did not carry on any business activity. It also transpired that BBR resigned from the directorship in the year 2009, and he continued to work for the company even after he resigned as a director. In the above background, the learned AO noted that BBR has 2 undisclosed bank accounts, one with Royal Bank of Scotland, another with State Bank of India, and certain deposits were made. The assessment for AY 67089 were completed, relying substantially on material seized from a third party, that is BVR group, including deposits in undisclosed bank account. So the nature of addition is, the addition was made on unexplained deposit in bank account in BVR name and agriculture income treated as a normal income, and the AO attributed these as assessee's unaccounted income on the premise that BVR is only a name lender or employee and not an independent stakeholder, and thus the real beneficiary of the assessee. The entire theory rested on the circumstances and the third party evidence and not on any seized incriminating material found during the search of the assessee's own premises. So the first appellant proceeded, CAT deleted the substantial addition, holding a lack of direct evidence connecting to the assessee, and upheld the genuineness of the agriculture income, noting that BVR as an independent business activity, because earlier I said they do not have any independent business activity, they are only an employee of the company. But whereas the CAT has deleted the addition, the department has agreed and appealed the assessee is cross-subject on judicial ground under 153A. So the legal question before ITAT, whether for concluded unabated assessment here, addition can be sustained purely on the basis of material loose sheets found in the possession of a third party, not during assessee's own search, in the light of Abhisar, Bilwell and allied precedents. So according to me, the addition is valid, because my reasoning is the material found during investigation is a part of a search proceedings. Because search is not a monetary act limited to physical seizure. It includes post-search investigation, collation of evidence, examination statement, inquiry. During search proceedings, the group company, the entire chain of transaction involving BVR came to light, including the undisclosed bank account. Although the bank account were in the name of BVR, they were unearthed as part of the investigation, and the search was on the group company. Hence, the material found during search for the purpose of 153A is valid. Another is, we have to see the substance over the form. BVR was only a Binami front run name lender. The AO's finding is supported by BVR held 1% share in 7 group companies. The assessee held 9% in, which has got a complete control. And they are resigned in the year 2009, but yet they continue to manage the affairs. Also, the assessee's wife legal has stated that he worked only for the group and did not conduct any independent business. This established BVR was not an independent entrepreneur and a trusted aid friend of the assessee. So the undisclosed accounts in the name represent the real income of the assessee, which is very important, because the court has recognized the McDowell case. The revenue is entitled to pierce the wheel and look at the real substance of the transaction. And another thing is, loose sheet and third party material have evidence value under the Income Tax Act, because section 132 4A and 292, which provides statutory presumption in favor of the revenue regarding seized documents even if found from third parties. These presumptions apply during search, assessment and appellate stages. So courts are held in various Supreme Court decision, High Court decision like P.R. Metrani. Document belonging to assessee discovered from a third party can be relied upon, and the Abhisar Bilwell cannot be applied mechanically. The reason being, the assessee in this case, the seized material post-search inquiries directly relate to the assessee. They reveal undisclosed on money arising from the transaction of the group company. Abhisar Bilwell applies only when no incriminating material whatsoever exists. Here incriminating material does exist, because undisclosed bank account of BVR discovered during search investigation and statement of the assessee and BVR legal heir and pattern of deposit relatable to the assessee's business. Hence the ratio of the decision factually distinguishable and does not restrict 153A power. Also, the revenue has got the right to tax the real income based on the McDowell's decision.
Your Honor, I am appearing for the respondent. The case is very clear. There is a person, there is an appellant, respondent here. He is director with another person in a group of companies, where the other person is supposed to take care of the affairs of the group, entire group. And he has been transacting on behalf of the group. That is very well brought by my friend. And if there is a transaction which is taken place, and during the search, if there is an incriminating material available that has two accounts of the other person, it cannot be directly linked with the appellant, the assessee here, the respondent, because incrementing material has a clear definition. I would like to take the attention of this bench that there 153 assessments, unabated years are extensively tied up with the evidence unearthed in search and the requisition. The incrementing material for each year is sine qua non to make an addition. In our case, basically the material which was found and the statement recorded clearly says it's only BVRs and nothing is connected to the respondent here for him to assume that he is the owner of it. And the question of merely BVR is a name lender, the AO never brought anything in the assessment order to say that he is a name lender, and there is a there has to be a past transaction even to prove that he was only doing name lending. But independently, even CAT appeal has found and he has given his reasoning while deleting the addition, then he is a business associate. When a business associate, he is an independent person and he can transact anything for himself. And that cannot be brought under the assessment of a person who is associated with him. And independently, and moreover, it is recorded he is handling the affairs in Chennai. And the respondent is not nowhere available in Chennai to handle this affairs because it's independently given to him. So the question, Abhisar Bildwell is 100% is applicable to the ratio laid down by the Supreme Court in this Abhisar Bildwell completely applies to the respondent. Because without incrementing material, nothing can be brought to tax. Further, loose sheets. Basically, these loose sheets which have been found in BVR's place and it was not found in the assessee's place. So, once it is found in some other's place, even assuming 292B, he says the document belongs to the person, it only belongs to the other person. It can never be brought to the hands of assessee. Assessee should, if assessee is holding those statements in his premises when it was found, during the search, then obviously there can be a link that an AO can assume that he is operating BVR's account. But when these statements were found in BVR's place, that other person's third party's statements and third party's records can never be brought into the assessment of an assessee. And particularly under 132.4, even if the statement is recorded, 132.1c is very clear. It says, first, before that, I would like to take you to the explanation to 132.4. For removal of the doubts, it is hereby declared that the examination of any person under the subsection may be not merely in respect of any books of accounts, other documents or assets found as a result of the search, but also in respect of all the matters relevant for the purpose of any investigation connected with the proceedings under the Income Tax Act 1922 or under this Act. See, very clear. Now, this explanation is clearly explains what is the relevance of evidence to be evidences that has been unearthed in the search to be linked with the assessment. When it is not found in my premises, even investigation cannot turn to assessee and say that it belongs to you, just because he was a business associate or he is another director of the group. So whatever on money so-called that was received by the director, it must be only BVR, because the facts itself, my learned friend said, he was handling the affairs of this group in Chennai. So when this has happened in Chennai, the person who is handling the case and the person who was transacting the case on behalf of the group is only liable and responsible for the on money that, if at all purported to have been received, is only liable to be added to in the account of BVR, not in the hands of assessee. I rely completely on Abhisar Bildwell, and regarding loose sheets, I even refer to Vishy Sukla's case. It's the first case on loose sheets cannot be taken as incrementing material for any proceedings. And I request you to kindly dismiss the appeal, Your Honor.
Clearly stated that BVR only looked up the affairs of the P group of the company, did not carry on any business activity. My learned friend said they are independent person. It is not so, because they are only looking after the group of the company and they are resigned from the directorship and they are getting only salary. So the Supreme Court in various decisions in Sumati Dayal and Durga Prasad held the courts must look at human probabilities and the real conduct of the parties. Human probability test supports the AO's finding that BVR has no source to generate such deposit. He was reduced to a friend employee. The assessee exercised complete financial and complete control. Therefore, unexplained deposit rightfully belonged to the assessee. And another argument 153 based on incriminating material unearthed during search triggered investigation. BVR was not an independent figure but a mere facade to root the assessee's money on money. The wide powers under 153A supported by statutory presumption under section 132(4)A and 292C and the doctrine of substance over form justify the addition made. Because section 132(4)A also clearly says where any books of accounts, any documents, money, bullion, jewelry or any valuable article or thing or found in the possession of control of any person in the course of such, it may be presumed that such books of accounts, other document, money, bullion or thing belongs to such person, The act itself is very clear. So it's a third party transaction. So we have to correlate the other 132(4)A and 292C along with 153A. So because the abyssal builders we cannot read in isolation.
I would like to conclude this with our final remark of my learned friend. My learned friend himself, he confirmed that what is in possession of a person belongs to that person. Point number one. Two. Second thing, Sumati Dayal or all the relevant cases where the additions have been made and upheld by the Supreme Court was only by the same person, not by third party. Sumati Dayal or Durga Prasad More, everything was on their own account. It was not on third party. So therefore, none of these things can be applied to the respondent assessed and maybe the appeal may be dismissed, Your Honor.
Just the practice notes on this is, you will have to first identify where the material was seized and when. In whose search, whether the warrant was there in his name or it was a general warrant on all the assessees together. So that is where you will establish whether it is a case which is covered by 153A or a 153C, because material seized from a third party cannot be used in a 153A assessment, because clearly there is a provision 153C which overrules saying that 153A is not applicable and 153C only should be used. So where you have this kind of a dichotomy, you will have to establish where the material was seized, when it was seized, and whether there is a warrant or not. And in the starting, the observation was made that the lands were sold by the companies and on monies were received by the director and deposited in that account of somebody. So you will have to also establish whether additions were made in the company's hands on the sale of those lands. So that if it is already made in the hands of the companies as on money, it could not have been made, because if it is arising out of a sale of a property, clearly identifiable based on those loose sheets, if it is recorded like that. So you will have to also say that it is not accessible in the assessee's hands, but it has already been assessed or whatever is the status on that. Basically, the crucial point is where the material was seized, found, and whether there is a warrant in the name of that person or it is a warrant in the name of your assessee with a place to search of that assessee. So all these are crucial points to highlight.
The choice of words will depend on the expertise in the subject. You can't expect the higher forums to have your knowledge. That's it.
Thank you, sir. Thank you to the presiding officers and councils for delivering a highly informative and dynamic move to session. Your expertise and participation made the simulation truly meaningful. We are grateful for your time and insights, sir. We invite Mr. C.A. K. Ravi, past chairperson, SIRC of ICA, to hand over the memento to councils C.A. Y. Sridhar and C.A. S. Muthu Abhirami. Sri Y. Sridhar, partner at Ramesh and Ram. So, like to...
Come on.
Sridhar, partner, Ramesh and Ramachandran, chartered accountant since 1990, bringing over 30 years of experience in audit and taxation. C.A. Muthu Abhirami, an advocate and chartered accountant with advanced qualifications including an ML in business laws, a post-qualification diploma in international taxation, and currently pursuing a PhD in taxation of electronic commerce. We invite C.A. Sudarshan K.R. to hand over the memento to counsel C.A. N. Arjun Raj and C.A. Yashwant Kumar. Arjun Raj expertise in income tax litigation while working under renowned income tax advocate Sri S. Sridhar, and Yashwant Kumar is an associate member of the ICA. He has strong interest in litigation. He specialized in direct taxation, worked with CRBS and associates. We invite C.A. Shankar to hand over the memento to counsel C.A. Y. Vishwanathan and S. Anand Babunath. C.A. M. Vishwanathan is a BCom graduate from Vivekananda College. He held the position of Senior Director at PKF Sridhar and Santanam LLP before joining MC Ranganathan and Co., where he currently heads the direct tax practice. Anand Babunath completed Bachelor of Commerce from DG Vaishnava College, qualified as Chartered Accountant from ICA, completed LLB in 2007 from Sri Venkateswara University. We would like to invite our chairperson CA Revati Raghunathan to give vote of thanks.
So I just will take 2 minutes because there's a very nice hot tea coffee break happening after this. I want to place on record my appreciation to both Mr. N.V. Vasudevan and Ramakrishnan, C.A. Ramakrishnan for actually, joining us. I called them and they immediately accepted, and I think the afternoon was very well spent for everyone. There was so much of takeaway. The cases which they had actually curated and the way the councils represented with so much of enthusiasm, I was just thinking, oh my God, if this was a real court or whether we are having a moot court proceeding over here. Thank you very, very much for curating and taking this program on the way, and to all the councils who accepted to come and participate and having put the work, and when they accepted immediately next day, where are the cases we need to prepare? All of them started asking where are the cases, and then I had to go back to the presiding officers and tell them, please give me the cases. The councils are now behind me for the cases. And today's success is because of the councils and because of the presiding officers and all the homework that they have done. And of course, for all the participation from all our professional members who have come and stayed with us throughout the day. Tomorrow we are having an equally interesting day with our a session in the morning by Jatin Christopher and Advocate Karthik Sundaram. And then in the afternoon we are having the moot court with the presiding officers from Mumbai. Advocate Ranjit Mehtani and Advocate Gopal Mundra, who were again very generous. Immediately they accepted. And we have counsels, 3 cases like this. We have counsels Karthik Sundaram and Jatin Christopher. They are doing a JDA matter. And then we are having Sharada Hariharan and Advocate Jayalakshmi. And then one matter where they have still not confirmed, Satyakumar and Disha Singh. These are the 3 teams who would be participating, and we will also be having some Courtcraft display over here tomorrow because that is what the presiding officers also want. And as usual, K. Ravi sir was the backbone in actually getting all the speakers and, helping to curate this entire thing. I don't claim any expertise in all these matters, and I run to him for help for everything, and he has been generous enough in helping me. So thank you once again to everyone who's here. For tomorrow's program, we have said that if you want to ask your partners or colleagues to join, we're giving, I think, 6 hours of CPE, and the fees is also reduced accordingly for tomorrow's program. So please encourage all your partners and colleagues to join. I also want to place on my appreciation to Vignesh, who has been a very good court master and who will be able to actually display his prowess again tomorrow, and to Shanmugapriya, Chartered Accountant, who came in as an MC today. And of course to the office, thank you very much. Morning 10 o'clock. Please come in on time at 10 o'clock so that we don't overshoot the timing also. Thank you very much, everyone. Please join us for coffee.
Thank you so much, ma'am. Thank for your valuable inputs. Yeah, we close for the day.